Good morning, everybody. Good morning, Annabella. Good morning, main mom of three. Good morning, Millie. Hello, Panda Bear's mom. Good morning, Janice. Okay, Janice. Yep, do what you got to do. Hello, hello, hello. Hello, Kendra. Good morning. Good morning, my beautiful people. Hello, hello. Hello, Marley. Good morning. I hope everybody's doing okay this morning. Jack of all trades, good morning. Kendra, good morning, good morning. Love y'all this morning. Thank you for being here. Absolutely, thank you for being here. We are on day 7. Trishy, 818, good morning. I'm glad you could join us too. True Crime Junkie, good morning. Hello, hello, hello. Welcome, everybody. Welcome. Hope everybody's having a great morning this morning. Got your coffee? Got your coffee? Got your Coke? Got your wine? Got everything. Now, we don't need no wine. We don't need no whiners in here. We're going to see a lot of whining probably from Yo-Yo Girl. Listen, she's trying to fool that jury. And then she's putting her hands over her face. And then she's peeking out the corner of her eye to look at the jury. Ain't that some shit? Good morning, Sue. Good morning, Sue. Hello, how are you, Miss Sue? Hope everybody's doing good. We are on day 7. Full credit goes to Court TV. Good morning, Guidance. Hope you're doing good, beautiful. Hello, hello. So yesterday, they found Megan's fingerprints were found on the trash bag, the trash can. Her DNA was on the gum. And of course, that was not good for the defense. They were a little bit flustered by the time Miss Tiger got up there. I like Miss Tiger, the medical examiner. Woo, Miss Tiger was something else. Miss Tiger was standing up for baby Evelyn. Did y'all like her? I can't say her name, Lord have mercy. Good morning, butterflies are free to fly. Miss Tiger was my cup of tea. Love Miss Tiger. Look at that beautiful baby, y'all, on the screen. The judge was going to hold her in contempt. Oh, that DA was dancing around. He couldn't stand it. She didn't answer that question. Yes or no. Yes or no. He was getting flustered. Oh, it's okay, Guidance. Do whatever you need to do and take a nap, honey. Guidance here, she does good. She has twins. I don't see how she does it all. Lord have mercy. She does a good job at everything she does. You need a nap. I'm sure you need a nap, honey. Peach State Mama, good morning. But I still think the prosecution is not, in my opinion, doing a very good job. I think that lady needs to sit all the way down, and I think that man needs to be on the other side. But hey, who am I? I'm just Smiley. I'm just here for the ride, honey. I'm here for the ride for these kids. I don't know who I'm going to call. I can't call nobody and say, hey, just remove this lady. You know, that ain't my job. But even though we're supposed to be on the same side, I think she's doing a crappy job myself. But like we say up here, I can't really say too much because like we say up here in YouTube land, maybe there is a method to her madness. But she sure got some madness going on, honey. Hey, Marguerite. Hey, Castle. Hey, everybody coming in. But now, if I was Tommy Boswell, I would be calling up there raising Cain, honey. I'd be like, something needs to change. Because something's mighty strange, right? Let's just hope there's a method to her madness. I hope so, Sue. I hope her mom, I don't think, how can she get out of not testifying? I mean, Jesus, she was arrested and everything else. I can't wait to see what she has to say. I bet she will. I bet she'll testify, and I bet her boyfriend will testify too. Because I bet they'll subpoena them. I bet they'll probably be a hostile witness. That's my thought. I could be wrong. Let's see. Hold on a minute. Did I hear that it may not be televised? Not sure if it's true. The part with her mom, and is that what you're saying? The part with the mom? Or the rest of the trial? I don't know. If they keep pissing that judge off, he ain't gonna televise it. Oh, let me see if I can find it again. Hold on a minute. Oh, I gotta show y'all something. Oh, I gotta show y'all something. Hold on. Where did it go? What did I do with it? Oh my God, what did I do with it? What did I do? Oh, look. The defense attorney was watching court TV in court yesterday. What do y'all think about that? They were reading all the comments and watching court TV. Now, live. Isn't that a little bit bizarre? What do y'all think about that? Yeah, that is wrong in my opinion. That's Mr. Scott. I hate this phone won't go longer. Let me do something here. Hold on a minute. Oh yeah. Let me brighten it up for y'all a little bit. Let me brighten it up a little bit. I don't know why my phone brightness always goes down. Hold on. Let me brighten this up for y'all a bit. That's Mr. Scott watching, her defense attorney watching court TV. Day 6. That was pretty bizarre, I think. Maybe that's where he was getting some of his questions at. I don't know. I think it's strange. But I don't know about that not being, oh, you're talking about the court still being live? I don't know. You know, some of the creators I know are there in the courthouse, where the trial is. So there may be some talk about it. And you know what? That may be the very reason why, Castle. That may be the very reason why the own freaking attorneys The own stupid attorneys, if you ask me. That's probably what they want. Also, they're fixing to start, but also there was text messages from between Megan and Hunter that was hey Beth Ann and everybody coming in, that was proven, well, she was keeping him in the dark, in my opinion. He didn't know anything, in my opinion, because she always had Evelyn here with her mother, there, everywhere, with Blue's Clues, Scooby-Doo. Oh, not Scooby-Doo. Lord, not with Scooby-Doo. But, you know, everywhere under the sun, but with wherever she was at. Good morning, Kimberly. She even had him at the bottom of the hill pretending to go up to Ethan's, seeing her daughter. How bizarre. Yeah, but it could be being said, Castle. They hear a lot of stuff. Creators are in there. Now, don't make it true, but that could be a rumor and hearsay. But it's ultimately up to the judge. So it could be some talk about it. And it could just be, remember, from day one where they got that information and they just ran wild with it. Good morning, Jacqueline. Heather, everybody, it's good to see you. Yeah, I think reading the comments, seeing what everybody's saying. I can't comment on Court TV because they have it on subscribers mode. I was just noticing that this morning. I'm like, woo, they must have a lot of subscribers. Not subscribers, I'm sorry. What you call that? Members. It's members only. They got it on members only because they're having no nonsense over there. And I thank y'all so much for being respectful in my chat. For the most part, the ones that have been timed out or blocked. This is a very serious case, y'all. And I try to say hello to everybody that comes in. If not, we try to overall say hi. My mods work hard to do that. We're not going to sit here and hold your hand. Hey, Connie, welcome. Good morning. This Smiley's chat is not the one for the games. And those of you who have been around for a long time, and there are some who have been around for a long time, when we're talking about a serious matter such as this, you can go bye-bye. My chat's not the one. I'm just telling you ahead of time before we get started this morning, because I don't know what you're trying to do over here. And some of you have your own channels. Wait, what? There's a time and a place for everything, and this is not it. We're all here to learn. We're here for Evelyn, and we're here for this, what's going on. So just remember that. Just remember that. You get so many chances. I heard somebody the other day say, oh, Smiley ain't going after Candace no more because so-and-so and so-and-so. Well, let me address that right now. Smiley ain't going after Candace. If you hadn't noticed, Smiley ain't even been doing summer. Okay? I haven't even done summer. So, in a long time, I'll keep her name and face out there once in a while. But check this out. Don't worry about what Smiley does. How about that? Hey, Tammy T and everybody coming in. Sunny days. Stephanie, good morning. Good morning, Lois. Happy Wednesday. Happy hump day. And I think everything coming unsealed that has been sealed for 5 years, we're going to be hearing and learning a lot that has not come out. So just hang on for the ride. Hang on for the ride, because there's going to be a lot to be learned in this. And if you listen and you learn, it can help you in other cases. It can help you in other cases. You're never too smart to learn. You're never too smart to learn, and you're never too old to learn. Yep, it's starting. I hope he's got his mic up a little bit more loud today. Hey, Gigi. I've never seen a judge like that. He's no nonsense, but I've never seen a judge like that comes in the courtroom, gets his clothes on, basically, and all that. Usually a judge is outside the court, and then as he's coming in, they say, all rise, and they're ready to go. He comes in and gets his stuff together and fiddle-faddles around and might go in and out, and he's in there when they say stand, and it's wild. It's wild. Never seen anything like it. He's got to give us a little tease every morning. Yeah, and then the orange band computer and folders. And I'm going to tell you what drives me crazy. Hello, where's Summer 1-800-TBI Fine? I'm going to tell you what drives me crazy about the judge's desk. I'm sorry. I figured out it's little rockets. I think it's rockets. He needs to remove those from his desk, because at first I was like, what does he have on his desk? That just don't look right. Your eyes can go deceive you. I am like, it took me about 3 days to figure out what that was. Y'all just look at it, especially the big orange one. I'm like, what has he got on his desk? I just, yeah, the space shuttle. I'm just like, that just does not look right. Did you think the same thing? We got dirty minds. I'm just like, what in the hell? I don't like it. I don't like it. I'm just going to tell you and be blunt. I don't like it. I'm like, what is that? A damn dildo or something? Get that off your desk, sir. I'm like, that don't even look right. And I understand it's a rocket, but the space shuttle, but from the outside looking in, honey, and people with glasses, people with eyesight problems, God, that don't look right. That's just bothersome, sir. Maybe I need to call up there and let them know. While you're telling him to turn his mic up, could you please tell him to remove the space shuttle, because it's bothering us. It's bothering me. I'm just going to be frank with you. Kimberly, Arnie Rose. Good morning, Nita. I am sorry. I am sorry. Oh, God. Rise and shine, mother cluckers. Oh, yes, I really did. Twice, Castle. I actually did. I literally did. I showed y'all the phone number. I really, really, really and truly did. Castle. I don't have a problem calling nobody. Like Stephanie said yesterday, Smiley's got 99 problems, but calling somebody ain't one. Oh, God. Oh, nerdy girl, Tanya, hello, good morning, good morning. Karen Best, hello, hello. Yeah, you think he's a closet? Oh my God. Oh God, you gonna get us all in contempt. They gonna get them subpoenas ready to come round us up. Oh, he got that orange going on. Well, we know his favorite color. His favorite color is orange. Big orange for Tennessee. Rocky Top, you'll always be home, sweet home to me. Good old Rocky Top. Rocky Top, Tennessee. Rocky Top, Tennessee. Oh my God. Oh, sing it, y'all. Sing it this morning. On top of old Smoky. Go ahead, Beth Ann, sing it. It's regular Folgers. Folgers in your cup this morning. Maybe he's from Texas. Yeah, maybe. Maybe he is from Texas. Yeah, Smiley will call it poor Cecil. No, Cecil Mills called me, honey. Kimberly, Cecil called me, baby. Cecil called me that morning. I was like, that was when I got my husband's phone. I'm like, holy shit. Well, I, that's how he got my number. I did call and leave a message, but he called me. And I seen that phone number and I'm like, holy crap. And I'm like, give me your phone, hurry up, because I didn't know how to record and all this stuff. So in all fairness, he called me. That's how I get my good interviews, baby. They want me. I'm like, holy smokes. Now, Miss Becky, in all fairness, I called her, what was it, 3 times? Lord, she had diarrhea of the mouth. I'm sorry, Miss Becky. You did now. Lord. Poor Jody Sue's like, and then later on she's like, I didn't really think that was Miss Becky but then come to find out, they know Smiley wasn't lying because Jesus, nobody could believe that lady. And I don't blame Jody Sue. Nobody believed that lady could be talking that much. Smiley just sit there and let her talk, I mean, 38 years working for the DA. What the hell? And then finally she's like, well, the police is here. The police is here. I ain't gonna talk to you no more. You're putting this all on YouTube. I'm about to lose my job. I'm about to lose my mind. Ronnie Lawson done sent him over here to guard me. Oh, Lord have mercy. What'd you expect, lady? Just saying. Yeah. It was, I kind of felt bad for putting that call out, but that was kind of odd, Kimberly. The stuff he was like, let me tell you first, I'm this and I'm that, and I mean, he was a very nice man. Don't get me wrong. I have nothing against Cecil Mills, nothing, except he should have put Brandon Lawson away for a lot longer. But he was like, you know, I'm not rich and I don't drive this car and I don't live in this house and stuff. And I'm like, holy smokes. I mean, that's what I'm thinking in my mind. And I'm like, and he's like, I'm African American. I'm like, sir, I don't care about any of that. You know, everything's just bizarre. Smiley gets in the wildest stuff, y'all. Yeah, Kimberly, Miss Becky was letting it roll, honey. She was letting it roll. Hey, Miss Magoo. Hello, how are you? I know. How long does it take to put on a robe? Lord. I wonder what Megan's going to have on today. This is becoming a fashion disaster, honestly. They need to do something with her hair. They need to put it up, put it back, put it something. She needs to have one of her inmates braid it for her. Anything. I don't know. Yeah, please don't speak negative about any other creators in this chat or channels today. Thank you, because you'll make Smiley be sending you back to other creators, and you'll be making Smiley be talking about creators, and I don't want to do that. I'll be sending you back to your home base. Let's all play nice today. Just saying. Don't come in here to stir the pot today. This is serious. Yeah, her hair would look pretty braided, but I don't think she cares. I don't know if she did or not. She didn't in the news wear glasses, Castle. But you know, nowadays, you can buy glasses that are not even reading glasses that people like to. My granddaughter tried that. I'm like, don't do that. You can wear glasses that are not even, you can just see right through them. It's some kind of fashion going on now. Or she could have needed them while she was in jail in the last 5 years, you know? All right, see? Come on, Judge. All right, wonder who's going to be on the stand today because they dismissed that one. Good morning, Fly Girl. Thank you for being here. Yeah, dusting off his trinkets. Oh, Lord knows. We need a few laughs this morning before this gets started. Oh, this is a sad case. Yeah, I mean, there's no telling who they'll be having. They could fly people in or anything, Sue. Yeah. They don't all have to be experts that was right here in the state or whatever. Hey, Cassie, good morning. Okay, honey, thank you. Y'all don't forget to hit the thumbs up button if you don't mind. Yeah, you talking about the lady that types? Yeah. Well, that courtroom, man, is bogged down. Well, where Summer, to be fair, what I remember, it's not like that in all the Tennessee courts, but man, from what I'm seeing here, these backwoods, I'm sorry, y'all, these courts in the outer, more out, is wild. Oh, look at her today. Pretty in pink. Yes, Carson. Not yet, Fly Girl, but it will be coming out. He might testify today. I think they're going to keep him more to the end. That's just my opinion. Thank you, Cassie. Please put some love on that like button. I'm going to be honest with y'all. That color does suit her. She looks terrible in black and all the dark colors. I'm just going to tell y'all like it is, honey. But it don't matter. She has an ugly heart and everything else, so that makes her ugly on the outside.
Oh, well, you told me 3 weeks, so I went ahead and typed it in for 3 weeks. But I've changed it on the original. So yesterday, the state indicated they may have another witness or at least exhibits. And then at the sidebar, I was told that there might be an objection to whatever the exhibit is.
Yes.
So I thought we'd take that up before I brought the jury in.
Yes, Judge. The state intends to introduce a certified copy of the order from Circuit Court in Bristol, Virginia, which ordered Hunter Wood involuntarily committed to the mental hospital over there in Marion. There's a copy of the appearance by the attorney over there, the request for evaluation and report to be done, and then there's a letter dated January 10th, 2025, which is
good morning, fun to see.
Southwestern Virginia Mental Health Institute updating the court as to Mr. Wood's status. And like I said, it is I believe, a self-authenticating document. There's a certificate of official record that is attached, signed by the judge of the.
Look at her taking notes about Hunter.
We have no objection, Judge.
Okay. So what I intend to do, and then after that, do you think we'll have any proof?
No, Your Honor.
So what I'll do is I'll bring the jury in, admit that, and the next number of exhibit, then you can rest in front of the jury. And then I'll have to send you back out so we can take up some matter. All right, we'll bring jury in.
Hey, tattoo mama.
Everyone stand, please. You may be seated. Thank you.
All right, General, call your name. Oh, wait, before we do that. Ladies and gentlemen, yesterday when we left, I gave you certain admonitions. Do any of the jurors have anything to report as far as those admonitions? If you do, raise your hand. Let the record reflect none of the jurors. All right,
Judge, at this time, the state would move to introduce what we believe is a self-authenticating document, which is an order from the Circuit Court in the city of Bristol, Virginia, which orders a mental health evaluation on Preston Hunter Wood. It also contains a letter from Southwestern Virginia Mental Health Institute, which is dated January 10th, 2025, which talks about the fact that he has been involuntarily hospitalized at that facility. We would offer that as the next exhibit in this case. 261, I believe.
261, any objection?
No, sir.
All right, that'll be exhibit 261. All right, call your next.
Judge, the state would rest.
All right, ladies and gentlemen, I know you've only been out here for 2.5 minutes, but I'm going to send you with the officer.
Everyone stand, please.
Oh, already? Hey, GG for
You
life.
may be seated. Thank you.
Mr. Scott, you have a motion?
Of course he does.
Judge, pursuant to Rule 29 of the Rules of Criminal Procedure, I move the court for a judgment of acquittal as to all counts. Just briefly, I'll go through them. As it relates to the first 3 homicide counts, the state has failed to prove the cause of death, which is required to be proven beyond a reasonable doubt. I understand the burden here is that the state has to prove it in a light most favorable to the state. The court has to look at it from that standpoint. Even when looking at that, Dr. Schmidt testified to various,
For an acquittal.
although she stated that she believed it was a asphyxia, she later under cross-examination admitted it could have been a SIDS death. She admitted that it could have been a heart issue, or it could have been a laryngeal spasm that caused the death. She really couldn't specify the manner of death. When it came to Dr. Malushnik, she testified that she felt like it was asphyxia caused by being placed in the trash can, but ultimately she did answer that she could not conclusively say that the baby was alive or dead before being placed in the trash can. As it relates to count 1 in premeditation, there is no evidence whatsoever in this case of premeditation. So those are the 3 murder counts. Aggravated child neglect, the state hasn't produced any evidence that the child was neglected in such a way to adversely affect his health and welfare. Similarly, of abuse, there's absolutely no proof in the record of child abuse. In fact, there is ample proof to the contrary. Both medical examiners testified there was no broken bones. There's no trauma there. The there's testimony, I think, from 6 lay witnesses talking about Megan was a good mother, a loving mother. They never saw any signs of abuse. The pediatrician testified that she never saw any signs of abuse, or she would have reported it under her duty under the law. So those are my arguments to those counts. As it relates to tampering with evidence, I'll leave that to the court's good discretion. False report, obviously, there is, as it relates to those, there is a double jeopardy issue that the court will have to address if the jury returns multiple verdicts on those. But I will leave those for now, but I do move for a judgment of acquittal without further argument. And the same with abuse of a corpse and failure to report a death. I'll move the court for a judgment of acquittal.
Yeah.
I'll be brief, Judge. Of course, the court reviews this motion and viewing the evidence in light most favorable to the state. As far as Mr. Scott's argument regarding premeditation, I think the proof's been pretty clear in this case. The child's found upside down, stuffed into a trash can with its head wrapped in a blanket, and then on top of that, there's a substantial amount of aluminum foil. I think that clearly shows an intent to murder. So we would argue that the element of premeditation
Morning,
is
Shannon.
at least shown through the physical evidence in this case. As far as the remaining counts, it's showing the cause of death. Both medical examiners, their opinions as they came in yesterday were that this was a homicide and that Evelyn Boswell died from asphyxiation. Mr. Scott certainly challenged and threw some other possibilities out there, but at the end of the day, that was their opinion as to the cause and manner of death. So I believe that the proof has been sufficient at this point to show how the child died and to let the jury make decisions on all the remaining counts.
Of course, as Mr. Scott and the general has stated, in viewing the evidence in light of the Rule 29 motion of judgment to kill, the court's required to view the evidence in the light of the most part of the state. And looking at these charges and through that lens, with regard to count 1, premeditation, I think coupled with the physical evidence of the way the child was wrapped and placed in the trash can, couple that with the voluminous amount of evidence where the defendant was given different stories as to where the child was.
They did that, Dan.
How the child was doing. When you look at that count in light of the statements the defendant was making on social media, the fact that there seemed to be, from the proof, there seemed to be a cutoff date where before that date, the defendant seemed to be very caring for the child, and after that day, there was story after story about where the child was. The defendant appears to have moved on to other things. And I think when you take all that evidence and a lot most favorable to the state, that the jury would be able to find premeditation. As for the cause of death, both medical examiners stated that in their professional expert opinion, the cause of death was asphyxiation. Again, Mr. Scott did a good job cross-examining those witnesses to introduce other potential theories. But courts of the opinion course of the opinion, the state, when looking at that proof, and what most favorable to the state, that they had put forth evidence that the jury can consider. So with regard to count one, I'm going to deny the motion for judgment of acquittal. With regard to counts 2 and 3, the abuse or the neglect, I think you've taken in light most favorable to the state the fact that that child was wrapped and placed in the garbage can. I think the jury can look at that. And I think that those facts taken along with all the other proof in the case. There was testimony that the child was filthy, dirty, toward the time late November, early December. I know that the one babysitter testified how dirty the child was. We saw pictures of the living condition of that trailer when the gentleman was cleaning it out. And I think that taking all that together, the jury would be warranted in finding abuse or neglect. I think that taking the lot most favorable to the state, those two counts would survive the Rule 29 motion, and I'm going to deny the motion with regard to those two counts. With regard to the tampering with evidence and false report charges, as well as the abuse of the courts and failure to report, when the court looks at all the statements, all the messages, all the social media posts, when you take those as a whole and view them in a light most favorable to the state, I think those are issues the jury can determine, and we'll have to. I'm going to deny the motion with regard to all counts for those reasons. Mr. Scott, first question that I have for you is, will the defendant testify?
Judge, we're prepared to state at this time the defendant will not be testifying.
All right. In that case, we have to go through the Loman versus State questioning, and I'm going to hand this down and let you do that.
Judge, for the purposes of the record, would you like her to come to the...
No, just put the microphone back up on the table for that. We just need to make sure she's recorded. Ms. Boswell, raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, ma'am?
Yes, sir.
Go ahead, Mr. Stein.
Megan, I want to ask you some questions about my representation as you explain to you your right to testify.
Okay.
I've been representing you for a couple of years now. We've met and discussed your case. You need to answer out loud.
Yes.
Okay. And part of that, I've talked to you about you have the right to testify. Is that right?
Yes.
And if the jury can't hold it against you if you don't testify, you understand that?
Yes.
You understand you have a right not to testify?
Yes.
And if you decided you wanted to testify, I couldn't stop you from that. Judge Goodwin couldn't stop you. Mr. Harper couldn't. That's solely your decision. You understand that?
Yes.
And after consulting with me and looking at the evidence and hearing the proof here in court, have you made a decision as whether or not you want to testify?
Yes, I have.
Do you want to testify?
No.
I think I covered it. That's approach.
Yeah. All right. We got other proof?
No.
No. I know it seems like a calisthenics exercise, but we need to bring the jury in I need to ask you that question in front of the jury, and then you can rest. And then I gotta send the jury out so we can finalize the charge and give the parties time. Because what we'll do, as soon as the proof closes, we'll take a break, and it'll be an extended break. We'll take a break so that I can get the charge finalized, and then what I do is I will make a notebook for each juror so that they can read and follow along as I read the charge to them. It's been my experience, especially after lunch, that fewer of them, not all, they read them with me. Plus, it gives them the charge when they go back in to deliberate. Each one of them has a copy of the charge so they can actually look at it and refer to it. And that also will give you time, because what I'll do is once the charge is done and I get the notebooks ready, we'll bring them back and I will read the charge to the jury up until almost the end. And then I will have you argue your case, and then I'll finalize it and send it out. That's the process going forward. And during this extended break, it will give you all time to go through your notes, go through the exhibits, organize your thoughts for closing argument. Okay? So we need to bring the jury. And I need to give the jury the instruction.
Yes, sir. I was going to ask about that, but I forgot.
I did too.
Everyone stand, please.
Good morning, Kitty, and everyone coming in that I missed. Hello.
You may be seated. Thank you.
All right. Okay, ladies and gentlemen, one thing I omitted to do a moment ago. Yesterday, during Dr. Malushnik, did I say that right?
Yes, sir.
At the very end of her testimony, she answered the question and then gave what I'm going to call a parting shot, that the answer was no, and that the baby would have to have been murdered some other way. Y'all remember that? Yes, sir. I'm going to instruct you that last phrase you're not to consider. That is outside of her expertise. Okay? It's a legal term, not a medical term. Does everybody understand that? Can everybody put that murder in some other way out of their mind and not consider? If you can, raise your right hand. Let the record reflect that all the jurors have raised their right hand. Now, Mr. Scott, the state has rested. Will the defense have proof?
Been at rest.
All right. Ladies and gentlemen, where we are now is the proof is closed, but it is not time for you to begin deliberating or talking about the case. We're going to have to take an extended break because I've got to prepare and finalize the jury charge. And then I'm going to make a notebook for each of you with the charge in it so you can follow along, and you'll have that for your reference while you deliver. Okay. This will also, what will happen is it'll probably take 45 minutes to an hour. I'll get all the notebooks.
No, because it's up to the state to prove their case.
Time to organize their thoughts for closing. When they come back,
I'm not sure that they proved it, but
and I will read you the charge, which will be painful, and I apologize for that, but that's the way it is. And then we'll go straight into argument. Okay? So I apologize for the length of the break, but just bear with me. It's necessary. You'll go with the option.
Everyone stand, please.
hold on a minute, y'all.
may be seated, thank you.
All right, we'll be in recess. We'll probably take.
Court stands in recess.
Wow. Going into closing arguments already today, day 7. What do y'all think? What do you think? They're going to take a short break. Yeah, I think the state, yeah, I think that they are, I don't care what, I shouldn't say that. I really shouldn't say that. Hey, Brian and everybody coming in. Yeah, it's a very thin line. We could be shocked. I'm telling you, we could be shocked. I shouldn't say this, but I'm going to tell you, it's already in their head. I mean, they swore on a Bible. They would disregard that. They got to get back there and argue that. They could be put in jail for lying, for if they even have that in their mind, even if they don't discuss it in the room. However, that is in their mind. That is in their mind. Where some are saying she's calling it guilty on all charges. I don't know. I'm telling you. I'm gonna be honest with you. Bren said Casey Anthony. So I'm gonna be honest with you. I'm kind of with Bren. This is, I know what she deserves, but I'm a little bit worried. I'm just gonna say it's gonna be 50-50. Some might say, well, she's been in there 5 years. She was 18. It's a little worrisome to me. I'm gonna be honest with you. Even Casey Anthony wasn't in jail, that long. Yeah, who's the father? It didn't come out, did it? Yeah, the state has to prove it, whether we like it or not. The state has to prove it beyond a shadow of a doubt. Did they? Did they? I don't know. I've been on many, many juries, and it's not what you say, one person. You've got to fight it out with the others. Absolutely, the state sucked, and I'm on their side. The state sucked. There's no 3 ways about it. Even if she walks where would she go, she's burnt so many bridges. I don't know. But that's not their problem, to be honest. I don't know. I don't even know what to say. Here we thought something was going to take 3 weeks, and we're only in the 7th day. I'm shocked. Beth Ann says guilty on all charges. Forever says, I believe they proved guilt, but agree with Shannon. She will get time served. That's what I'm kind of thinking. I'm thinking she'll get time served. That's what I'm thinking. That's the question. We're going to be on jury watch now. But will it be today? It may be a short. I got to have some nicotine, y'all. I ain't going to lie. Y'all sit here and talk amongst yourselves. I'm going to have my phone with me. I got to have some nicotine on this. I'm not going to lie. I got to think about this a minute. I can't even commentate right now. As fast as Murdoch, yeah. Just pray. Lord have mercy. That's what you know who's going to get if they are in court, in my opinion. That's what you know who's going to get if they are in court, in my opinion. I just pray that these jurors get it right because, oh my God, I'm worried. Usually I have a lot of faith, but this is just weird to me. This is the time I need to pull out my little book. All right, we're going to talk about justice. Deuteronomy 32:4. He is the rock. His works are perfect. All his ways are right. He is faithful. He doesn't do anything wrong. He is honest and fair. Psalm 14:12. The Lord secures justice for the poor and upholds the cause for the needy. Psalm 106:3. There is joy for those who deal justly with others and always do what is right. Why is it better to let God be the judge? Dear God, there are times when I want to punish those who make me feel bad. I know now that it is your job. Help me to give you all my problems because you are the perfect judge. Talk about faith. No, there's not any main mom of three, not yet. And it may be a while because it was skeletal remains, but no word on that at all yet. But let's talk about faith just a minute. Peter 1:21 says, through Christ you have come to trust in God, and you have placed your faith and hope in God because he raised Christ from the dead and gave him great glory. And Matthew 17:20, because your faith is much too small, what I'm about to tell you is true. If you have faith as small as a mustard seed, it is enough. You can say to this mountain, move from here to there, and it will move. Nothing will be impossible for you. The important thing is faith, the kind of faith that works through love. Faith is confidence in what we hope for and assurance about what we do not see. Hold on just a minute. Hello. Good morning, Butter Biscuit. Hello, hello. Hello, everybody coming in. Thank you for being here. We're just waiting on everybody to come back from their recess. And then I guess they'll start their closing arguments. Yeah, he's probably relieved he wasn't called to the witness stand. This was a bizarre thing from the state, and I don't know. Baba Rose, good morning. Connie, mama of 2 boys, hello. So faith, what gives you faith and hope in Jesus? Dear God, faith is a confusing thing. It's not something I can see or touch or hear, but it is trusting you in my heart. I know Jesus died for me so I could live with you in heaven one day. Please live in my heart today, Jesus. I want you to be with me always. Look, we just got to have faith, trust, hope, all the things. All the things. That justice is going to be served, even though we're a little worried, all of us. Yeah, I say that, Mom of 3. The state should have had all their ducks in a row. There are a few pieces of bread short of a picnic, if you ask me. Yeah, they have to go through the charges to the jury, then the closing arguments, Mohawk Mom. Good to see you, Mohawk Mom. Thank you for being here. Everybody, thank you for being here. I appreciate you so much. I wonder if this was their first, the prosecution's first big case, because I don't know. I just pray they get it right. Yep, that's absolutely right. And I just pray to the good Lord above, they don't give her time served. Yep, she's not testifying. And, you know, this is just my opinion and my thoughts. Because I really thought she would testify because she's too, she's got an imagination and she loves the limelight. This is just my thoughts and my opinion only. I really think by her defense, the way that things went yesterday, I don't think wild horses could have stopped her from testifying, in my opinion, from what I saw in the last, let's just say, 6 days. I think that the attorney, Scott, the defense attorney, told her, and this is just my opinion, after yesterday he talked to her and he said he thinks he has a slam dunk case. just look, they threatened to put the medical examiner in jail, yada, yada. And I think he really has her convinced that she can walk. And after he asked for the acquittal today, and the judge asked, was she going to testify? And she said no, because I think she has a lot of confidence that she's going to walk. He's already asked for a mistrial, and he has done everything that he can for her as a public defender. Usually they don't work that freaking hard, to be honest with you. So, in my opinion, the public defender's worked harder than the state has, and that's very unusual, but whatever. No, Sherry, I don't think he approved all 20 charges. They took one or two off the table at the beginning. If I'm not mistaken, don't quote me on it. I think it's 18, but I'm not. I can't be 100% sure. I just say that this trial was very odd. Hey Jude, if I was that lady, I would hang my hat if she's going to be like that kind of prosecutor. I don't know. I hope that it's a short one. I agree with you, JoJo. I thought the whole week was with the prosecutors was very weak. They were very weak in everything that they did. Everything. Did they even object at all? Maybe one or two times? Jesus. And I think there was one more. Why didn't they call? There was 3 medical examiners. Why didn't they call the other medical examiner? I was expecting more today. Hey, H. Davis. Good morning. We're in recess right now. They're going to do closing arguments today. They asked for an acquittal, so we don't know what's going to happen. They denied the acquittal, and I don't know. We may have answers tonight or in the morning. I guess we'll know when the judge gets back, because I hope they give her no parole. They could probably put anything on the table. It's up to the jury, I guess. I don't know. There's a statute of limitations, I guess, but can they and will they? I don't think the state will. I think the state actually would have to do that. They would have to have proof. And it's already been said that he's been cleared through the TBI and LE. I don't think they personally will, myself. I mean, there's no proof. Where's the proof? And they didn't get her mom up there either. I mean, nothing. She could have been a hostile witness. Yeah, there was no proof that Hunter was involved at all. And there was those text messages yesterday. She was deceiving Hunter. I am too, because it wasn't like he just committed himself, and he'd been in there a couple of months. Wasn't like he just went in either. Right, Sherry Berry. And I feel like if she does get out now, it's probable that she's going to have more kids, end up doing the same thing. And even if she don't have more kids, then she's going to harm someone else's kids. She definitely is not the motherly type. Or she's going to end up in some type of trouble again. If she did this at such a young age, in my opinion, she's a whole lot worse or fabricating stuff than Casey Anthony ever was, in my opinion. And she has probably learned so much, so many more crimes in jail. It's just, she has nowhere to go. She's burnt every bridge she's crossed. People can change, but not this one, in my opinion. Yeah. But I'm just saying they didn't even try. They didn't even, in my opinion, they didn't even try to do nothing. I'm just saying there's so many involved in this case that they could have called, but they didn't. Yeah, she's going to try to trap another man. She'll try to do whatever she can to get a home. Y'all saw those pictures. She already thought she was going to live high on the hog with Hunter. Yeah, she would have set up her father if she could have done it without him knowing it, in my opinion. I don't know. Always. I don't know if she's in general public in jail or not. Yeah. Hey, Grace. Yeah. Yeah, they do treat women differently. Hey, Grace. Grace is gavel. You still in here? Grace, I don't mind you being in here. You're welcome to be in here, but I forgot, and I don't mean to put you on the spot in here in front of my people, but I forgot that you're the one that kind of stirred the shit on my friend Justin, Touched Them Pearls, on the Nancy Grace thing. And I just want to let you know, you can be here, but we're not going to have any problems in here this morning. And just so you know, Justin is my friend. Only all here till the end. Just saying. And I just want you to know that. Okay? I just want you to know that. Beth Ann, please stay out of this. I'm not speaking to you. So I addressed all that this morning, and before we got started. Okay, if there's a misunderstanding, I just wanted you to know. Okay, you're welcome to be here, but I'm not. I just wanted to address that. I didn't want people to think that I was like, oh, hey, Grace, and being two-faced. I just wanted you to understand. I realize who you are now, okay? But you're fine to stay. Okay, I don't care about the misunderstandings and all that. I just wanted you to know. And if anybody has a problem with anybody else in the chat, y'all can block each other. I'm just letting you know now. We need to focus on Evelyn and what's going on here. I didn't say anything this morning, Grace. Okay? I can tell you this, Justin don't address nobody because he has grace. Nobody. But when he does, there's something going on. Grace, that's the last time I'm going to say it. And if you want to speak to him, do. I'm just addressing you, and I let you know, don't bring it up again. This is my live. Don't bring it up again. You know how to get a hold of him. allforjustice@gmail.com. That's enough. We'll move on now, or I will block you myself. I don't take kind to stuff like this. I am too, Annabella. I am too, and I just hate the way that it had to. Connie, I believe because her attorney actually told her, good morning, Janice. I believe actually after yesterday, her attorney told her that he had a slam dunk. That's just my opinion, in my opinion only. Because I believe wild horses couldn't keep her away. She had such an imagination. No, they're not on lunch at 9:41 a.m. or 10:41 their time. They're in recess because they tried to get an acquittal, and that didn't happen. So they rested their case, and they're gonna have they're gonna turn it over to the jury today for closing arguments. It went pretty fast this morning. I mean, they wasn't in there like 2-3 minutes before the judge dismissed them and then brought them back in because Mr. Scott said, hey, he wanted an acquittal. Well, that didn't fly. That did not fly at all. Yeah, the judge is getting everything ready for the jury that they'll need for their deliberations. So he can tell them, give them instructions, tell them what they can do and not do. Yeah, they're still on break sunny days. And the defense, that was odd. And the defense called no witnesses, 0. They said it was the burden of the prosecution, which it is. Yep, they had 0 witnesses. They're very confident, but I think that's why Megan didn't, I think that's why she didn't testify. They told her after yesterday, and this is just my opinion and my theory only, I think they told her, look, the judge was going to give the medical examiner contempt of court. We got this. You don't have to testify. If you get up there and testify, the jury's going to be watching your every move. Here we go. Well, he'll have to come back in there and put his robe on 75 times, but here we go. Yeah, drive safe. I agree with you at first. I thought it was the other way around, but he did a very good job, I think, in my opinion. Yeah, that too. I don't know if she would have got angry or not, but she definitely would have lied. Yeah, or he told her he could get her off, and then, or there's a chance she could walk, and then, but if she got up there and lied, then she'd be staying in jail.
All right. I'm going to ask this one last time. Have y'all reviewed the final charge, or the charge in its final form?
I have, Judge.
I have to.
And on behalf of the state, General, do you accept the charge as written?
Yes, Judge.
Mr. Scott, on behalf of the defendant, do you accept the charge as written?
Yes, sir.
All right. What I'm going to do, it's 81 pages long. I'm going to bring them in, give them the charge. I'll probably, of course, I have to read all the judgment forms. If you look at it on page 49, I'm going to read down to, I'm going to stop where it says when you retire to the jury room. I'm going to wait and give them that part after y'all argue.
Wonder if he got his mail.
I would ask if the state's ready, but I think General Harper just left.
He's coming right now. He left his copy of the jury instructions on his desk. He's just grabbing them. The state is otherwise ready.
And I won't say it.
Sonia, love
I'm
you.
sure I won't
Thank you
think
so
to say it,
much.
but the presentment is required to go back with the jury charge, and it's in the back of the book.
Your Honor, count 18, was that redacted out? Just make it sure.
Yep.
Thought we did.
Yep.
Absolutely 100.
All right. Is the state ready to proceed? Defense ready to proceed?
Yes, Judge.
Then let's bring the jury in.
Everyone stand, please. You may be seated. Thank you.
All right. All right. In the criminal court for Sullivan County, Tennessee, at Blumble, State of Tennessee versus Megan Boswell, defendant, case number S72869, date February 3rd through 12, 2025. Count 1, first degree premeditated murder. Count 2, first degree murder in the perpetration of felony. Count 3, first degree murder in the perpetration of felony. Count 4, aggravated child abuse. Count 5, aggravated child neglect. Count 6, tampering with evidence. Count 7 through 17, false report. Count 19, abuse of a corpse. Count 20, failure to report a death under suspicious, unusual, or unnatural circumstances. Jury instructions. Members of the jury. Count 1 of the presentment charges the defendant Megan Boswell with the offense of premeditated first-degree murder. This offense embraces the lesser included offenses of facilitation of premeditated first-degree murder, attempt to commit premeditated first-degree murder, facilitation of attempt to commit premeditated first-degree murder, second-degree murder, facilitation of second-degree murder, attempt to commit second-degree murder, facilitation of attempt to commit second-degree murder, voluntary manslaughter,
facilitation of voluntary manslaughter, attempt to commit voluntary manslaughter, facilitation of attempt to commit voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, facilitation of criminally negligent homicide, child abuse, child neglect, attempt to commit child abuse, attempt to commit child neglect, assault, attempt to commit assault, and misdemeanor reckless endangerment. Count 2 of the presentment charges the defendant Megan Boswell with the offense of first-degree murder in the perpetration of a felony. This offense embraces the lesser-included offenses of facilitation of first-degree murder in the perpetration of a felony, attempt to commit first-degree murder in the perpetration of a felony, facilitation of attempt to commit first-degree murder in the perpetration of a felony, second-degree murder, facilitation of second-degree murder, attempt to commit second-degree murder, facilitation of attempt to commit second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, attempt to commit voluntary manslaughter, facilitation of attempt to commit voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, facilitation of criminally negligent homicide, child abuse, attempt to commit child abuse, assault, attempt to commit assault, and misdemeanor reckless endangerment. Count 3 of the presentment charges the defendant Megan Boswell with the offense of first-degree murder in the perpetration of a felony. This offense embraces the lesser-included offense of facilitation of first-degree murder in the perpetration of a felony, attempt to commit first-degree murder in the perpetration of a felony, facilitation of attempt to commit first-degree murder in the perpetration of a felony, second-degree murder, facilitation of second-degree murder, attempt to commit second-degree murder, facilitation of attempt to commit second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, attempt to commit voluntary manslaughter, facilitation of attempt to commit voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, facilitation of criminally negligent homicide, child neglect, attempt to commit child neglect, assault, attempt to commit assault, and misdemeanor reckless endangerment. Count 4 of the presentment charges the defendant Megan Boswell with the offense of aggravated child abuse. This offense embraces the lesser included offenses of facilitation of aggravated child abuse, attempt to commit aggravated child abuse, facilitation of attempt to commit aggravated child abuse, aggravated assault, facilitation of aggravated assault, attempt to commit aggravated assault, facilitation of attempt to commit aggravated assault, reckless aggravated assault, facilitation of reckless aggravated assault, misdemeanor reckless endangerment, child abuse, attempt to commit child abuse, assault, and attempt to commit assault. Count 5 of the presentment charges the defendant Megan Boswell with the offense of aggravated child neglect. This offense embraces the lesser included offense of facilitation of aggravated child neglect, attempt to commit aggravated child neglect, facilitation of attempt to commit aggravated child neglect, aggravated assault, facilitation of aggravated assault, attempt to commit aggravated assault, facilitation of attempt to commit aggravated assault, reckless aggravated assault, facilitation of reckless aggravated assault, misdemeanor reckless endangerment, child neglect, attempt to commit child neglect, assault, attempt to commit assault. Count 6 of the presentment charges the defendant Megan Boswell with the offense of tampering with evidence. This offense embraces the lesser included offense of facilitation of tampering with evidence, attempt to commit tampering with evidence, and facilitation of attempt to commit tampering with evidence. Count 7 through 17 of the presentment charges the defendant with Megan Boswell with the offense of false report. This offense embraces the lesser included offenses of attempt to commit false report. Count 19 of the presentment charges the defendant Megan Boswell with the abuse of a corpse. This offense embraces the lesser included offense of facilitation of abuse of a corpse and attempt to commit abuse of a corpse. Count 20 of the presentment charges the defendant Megan Boswell with the offense of failure to report a death under suspicious, unusual, or unnatural circumstances. This offense embraces the lesser included offense of attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances. The presentment in this case is the formal written accusation charging the defendant with these charges. It is not evidence against the defendant and does not create any inference of guilt. To this presentment and each offense charged and included therein, the defendant has entered a plea of not guilty. The evidence in this case has been completed and final arguments will take place momentarily. Now it is my duty to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks that I have made, do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. As to any question to which an objection was sustained, you must not speculate as to what the answer might have been or as to the reason for the objection, and you must assume the answer will be of no value to you in your deliberations. You must not consider for any purpose any offer of evidence that was rejected or any evidence that was stricken out by the court, such matters to be treated as though you had never known it. You must never speculate to be true any insinuation suggested by a question asked of a witness. The question is not evidence and may be considered only as it supplies meaning to the answer. Whenever the singular of a word is used in these instructions, it may be taken equally to mean the plural unless clearly inapplicable. Whenever the word he is used in these instructions, you may consider it as applying equally to a woman. The law presumes that the defendant is innocent of the charge against her. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless, from all the evidence in the case, you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove her innocence. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. A conviction cannot be based on conjecture, suspicion, or a mere belief that the defendant is guilty of the crime charged. Reasonable doubt is a high burden, but it does not mean proof to an absolute certainty. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of the offense. Reasonable doubt does not mean a captious, possible, or imaginary doubt. A reasonable doubt is not a whim, it is not speculation or suspicion. It is not an excuse to avoid the performance of an unpleasant duty, and it is not sympathy. A reasonable doubt is a doubt based upon reason and common sense after careful and impartial consideration of all the evidence in this case. The state must have proved beyond a reasonable doubt all the elements of the crime charged, that the crime, if in fact committed, was committed by the defendant before the finding and returning of the presentment in this case. The date of the offense is not an essential element of any of the offenses charged in the presentment or any lesser included offense. The state is not required to prove beyond a reasonable doubt a specific date upon which any of the alleged offenses occurred. The state is only required to prove beyond a reasonable doubt that the alleged offenses occurred before the finding and returning of the presentment in this case. The burden is upon the state to prove by preponderance of the evidence that this offense was committed in Sullivan County, Tennessee. Proof by preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by preponderance of the evidence that this offense was committed or consummated in Sullivan County, Tennessee, then you must return a verdict of not guilty. If you have read or heard anything about the case other than in open court, you should disregard what you read or heard and base your verdict only upon the law and evidence presented under the direction of the court. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all the evidence in light of your own observations and experience in life. You are the exclusive judge of the credibility of the witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile them if you can, without hastily or rashly concluding that any witness has sworn falsely, for the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to the proof of, if any, of his or her general character, the evidence, if any, of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any, are shown, and all the evidence in the case tending to corroborate or to contradict him or her. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance to his or her evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such out-of-court statements. Further, a witness may be impeached by careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue. except where it's corroborated by other credible testimony or by the facts and circumstances proved in the trial. Your decision on the facts of this case should not be determined by the number of witnesses testifying for or against a party. You should consider all of the facts and circumstances in evidence to determine which of the witnesses you choose to believe or not to believe. The defendant has the right to remain silent, that is, the right not to testify. You shall not consider such silence as evidence of guilt, and you can draw no inferences of guilt from such silence or decision not to testify. You are reminded that the state has the burden to prove guilt of any offense beyond a reasonable doubt. Evidence has been introduced in this trial of a statement or statements by the defendant made outside the trial alleged to show an admission against interest. An admission against interest is a statement by the defendant which acknowledges the existence or truth of some fact necessary to be proven to establish the guilt of the defendant, or which tends to show guilt of the defendant, or is evidence of some material fact but not amounting to a confession. While this evidence has been received, it remains your duty to decide if in fact such statement was ever made. If you believe a statement was not made by the defendant, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the facts stated. In so determining, consider the circumstances under which the statement was made. Also, consider whether any of the other evidence before you tends to contradict the statement in whole or in part. You must not, however, arbitrarily disregard any part of any statement, but rather should consider all of any statement you believe was made and is true. You are the sole judge of what weight should be given such statement. If you decide a statement was made, you should consider it with all the other evidence in the case in determining the defendant's guilt or innocence. Expert witness. During the trial, you heard the expert testimony of Dr. Matrina Schmidt, who was described to us as an expert in the field of forensic pathology, Dr. Darinka Polchan, who was described to us as an expert in the field of forensic pathology, Paul Durant, who was described to us as an expert in the field of forensic analysis of digital devices, Marla Gray, who was described as an expert in the field of serology and DNA analysis, and David Hoover, who was described to us as an expert in the field of latent fingerprint identification. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state their opinions concerning such matters and give reasons for their testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reason, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Evidence. You may have heard two types of evidence in this case. One type of evidence is called direct evidence, and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which referred to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. The law makes no distinction between the weight that you should give either direct or circumstantial evidence. It is for you to decide how much weight to give any evidence. The crime charged or included in each count of the presentment is a separate and distinct offense. You must decide each charge separately on the evidence and law applicable to it. The defendant may be convicted or acquitted on any or all of the offenses charged or included. Your findings as to the crimes charged must be stated in your verdict. You will not be provided with a transcript of the testimony. However, you were permitted to take written notes. Notes taken by a juror to be used only as an aid to the memory of that juror alone and may not be used as authority in the jury deliberation room. The fact that something has been reduced to writing does not make it more significant than matters not noted down, and does not make it more accurate than independent memory. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. You may not use any electronic device or media such as a telephone, cell phone, smartphone, iPhone, BlackBerry, or computer the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including all social media, to communicate to anyone any information about this case, or to conduct any research about this case until you have returned your verdict and the trial has concluded. The court will now instruct you as to the law applicable to all counts of the presentment. Count 1, premeditated first-degree murder. Any person who commits the offense of premeditated first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally, and 3, that the killing was premeditated. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time she allegedly decided to kill must be carefully considered to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. If you find from the proof beyond a reasonable doubt that the defendant is guilty of premeditated first-degree murder, then the jury will not fix a fine. If you have a reasonable doubt as to the defendant's guilt of premeditated first-degree murder as charged in the presentment, then your verdict must be not guilty as to this offense. Count 2, first-degree murder in the perpetration of a felony. Any person who commits first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the killing was committed in the perpetration of or the attempt to perpetrate the alleged aggravated child abuse. That is, that the killing was closely connected to the alleged aggravated child abuse and was not a separate, distinct, and independent event. And 3, that the defendant intended to commit the alleged aggravated child abuse. The following essential elements apply to aggravated child abuse. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the act of abuse resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged aggravated child abuse. The killing may precede, coincide with, or follow the aggravated child abuse and still be considered as occurring in the perpetration of the aggravated child abuse, so long as there is a connection in time, place, and continuity of action. Knowingly means that a person acts knowingly with respect to the conduct or the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct when it is the person's conscious objective or desire to engage in the conduct. Child and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of first-degree murder in the perpetration of a felony, then the jury will not fix a fine. If you have a reasonable doubt as to the defendant's guilt of first-degree murder in the perpetration of a felony, as charged in the presentment, then your verdict must be not guilty as to this offense. Count 3, first-degree murder in the perpetration of a felony. Any person who commits first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the killing was committed in the perpetration of or the attempt to perpetrate the alleged aggravated child neglect. That is, that the killing was closely connected to the alleged aggravated child neglect, and was not a separate, distinct, and independent event. And three, excuse me. Three, that the defendant intended to commit the alleged aggravated child neglect. The following essential elements apply to aggravated child neglect. One, that the defendant knowingly neglected a child so as to adversely affect the child's health and welfare. And two, that the act of neglect
I
resulted
love
in
you
serious
all.
bodily
Thank you
injury
for
to the
being here
child.
so much.
And three, that the child was 8 years of age or less. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged aggravated child neglect. The killing may precede, coincide with, or follow the aggravated child neglect and still be considered as occurring in the perpetration of the aggravated child neglect, so long as there is a connection in time, place, and continuity of action. Knowingly and intentionally had previously been defined for you on page 15 of these instructions. Child and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of first-degree murder in the perpetration of the felony, then the jury will not fix a fine. If you have a reasonable doubt as to the defendant's guilt of first-degree murder in the perpetration of a felony and was charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted knowingly. Knowingly means that a person acts with an awareness that his or her conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally has been previously defined for you on page 13 of these instructions. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. If you find from the proof beyond a reasonable doubt that the defendant is guilty of second-degree murder, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as the defendant's guilt of second-degree murder is charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally or knowingly, and 3,
No
that
call,
the killing
call
resulted
our
from a
lady.
state of passion produced by adequate
Against it,
provocation
against anybody.
sufficient to lead a reasonable person to act in an irrational manner. Intentionally has been previously defined for you on page 13 of these instructions. Knowingly has been previously defined for you on page 17 of these
Hi,
instructions.
YouTuber. Everybody coming in.
The
Hello.
requirement of knowingly is also established if it is shown the defendant acted intentionally. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation, sufficient to lead a reasonable person to act in an irrational manner. If you find from the proof beyond a reasonable doubt that the defendant is guilty of voluntary manslaughter, then you may fix a fine in any amount not greater than $10,000, and you'll so report your fine on your verdict form. If you have reasonable doubt as to the defendant's guilt of voluntary manslaughter as charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, and 2, that the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also shown or established if it is shown that the defendant acted knowingly or intentionally. Intentionally has been previously defined for you on page 13 of these instructions. Knowingly has previously been defined for you on page 17 of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless homicide, then you may fix the fine in any amount not greater than $5,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of reckless homicide as charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the
He's
alleged
tired,
victim.
Lord. I would
And
be.
2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim would be killed. The risk must be of such a nature and degree that his failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown the defendant acted intentionally, knowingly, or recklessly. Intentionally has been previously defined for you on page 13 of the instructions. Knowingly has been previously defined for you on page 17 of the instructions. Recklessly has been previously defined for you on page 19 of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of criminally negligent homicide, you may fix a fine in any amount not greater than $3,000, and you'll so report your fine on your verdict form. If you have reasonable doubt as to the defendant's guilt of criminally negligent homicide as charged and included in the presentment, then your verdict must be not guilty as to this count. Lesser included offense counts 1, 2, and 4. Child abuse. Any person who commits child abuse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of child abuse, you may fix the fine in any amount not greater than $2,500, and you so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of child abuse as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 3, and 5. Child neglect. Any person who commits child neglect is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly neglected a child so as to adversely affect the child's health and welfare. And 2, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of child neglect, then you may fix the fine in any amount not greater than $2,500, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of child neglect as charged in the presentment, then your verdict must be not guilty as to this offense. Count 4, aggravated child abuse. Any person who commits the offense of aggravated child abuse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the act of abuse resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and serious bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated child abuse, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of aggravated child abuse as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 4 and 5, aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intentionally or knowingly caused bodily injury to another, and 2, that the act resulted in serious bodily injury. For purposes of this count, intentionally, knowingly bodily injury and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated assault, then you may fix a fine in any amount not greater than $10,000, and you'll so report your fine on your verdict form. Excuse me. If you have a reasonable doubt as to the defendant's guilt of aggravated assault as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 4 and 5, reckless aggravated assault. Any person who commits the offense of reckless aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant recklessly caused bodily injury to another, and 2, that the act resulted in serious bodily injury. For the purpose of this count, recklessly bodily injury and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless aggravated assault, then you may fix a fine in any amount not greater than not greater than $5,000. And you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of reckless aggravated assault as charged in the presentment, then your verdict must be not guilty as to this offense. Ladies and gentlemen, anytime that I make a change, I'm making the change in the notebook that's black. It says original charge. This is the official original charge. Those are just your copies, okay? Lesser included offense counts 1, 2, 3, 4, and 5. Assault. Any person who commits an assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant caused bodily injury to another, and 2, that the defendant acted either intentionally, knowingly, or recklessly. For purposes of this count, intentionally, knowingly, recklessly, and bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of assault, then you may fix a fine in any amount not greater than $2,500, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of assault as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, 3, 4, and 5, misdemeanor reckless endangerment. Any person who commits the offense of misdemeanor reckless endangerment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury, and 2, that the defendant acted recklessly. For the threat of death or serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you can convict the defendant, the state must show beyond reasonable doubt that a person or class of persons was in the zone of danger. The zone of danger is that area in which a reasonable probability exists that the defendant's conduct would place others in imminent danger of death or serious bodily injury. For purposes of this count, recklessly, intentionally, knowingly, and serious bodily injury are defined for you in the definition section of these instructions. The requirement of recklessly is also established if it is shown the defendant acted intentionally or knowingly. If you find from the proof beyond a reasonable doubt that the defendant is guilty of misdemeanor reckless endangerment, then you may fix a fine in any amount not greater than $2,500, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of misdemeanor reckless endangerment as charged in the presentment, then your verdict must be not guilty as to this offense. Count 5, aggravated child neglect. Any person who commits the offense of aggravated child neglect is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly neglected a child so as to adversely affect the child's health and welfare. And 2, that the act of neglect resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Adversely affect the child's health and welfare, child, and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated child abuse, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. That should say neglect. All right, let me reread that. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated child neglect, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of aggravated child neglect as charged in the presentment, then your verdict must be not guilty as to this offense. Count 6, tampering with evidence. Any person who commits the offense of tampering with evidence is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew an investigation was in progress, and 2, that the defendant concealed a thing with the intent to impair its availability as evidence in the investigation. For purposes of this count, knew, conceal, destroy, and bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond reasonable doubt that the defendant is guilty of tampering with evidence, then you may fix a fine in any amount not greater than $10,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of tampering with evidence as charged in the presentment, then your verdict must be not guilty as to this offense. Count 7 through 17, false report. Any person who makes a false statement to law enforcement officer is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the statement was made by the defendant. 2, that statement was made in response to a legitimate inquiry by a law enforcement officer. And 3, that the statement would concern a material fact about an incident within the officer's concern. And 4, that the defendant knew such statement was false. And 5, that the statement was made by the defendant with the intent to obstruct or hinder the officer from preventing an incident from continuing to occur.
Yeah, it may take a little bit longer because they'll have to decide for each charge, and she's got a lot of charges.
Count, new and law enforcement officer are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of false report, then you may fix a fine in any amount not greater than $5,000, and you so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt in a false report as charged in the presentment, then your verdict must be not guilty as to this offense. Count 19, abuse of a corpse. Any person who commits the offense of abuse of a corpse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant physically mistreated a corpse in a manner offensive to the sensibilities of an ordinary person. And 2, that the defendant acted without legal privilege. And 3, that the defendant acted knowingly. For purposes of this count, knowingly is defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of abuse of a corpse, then you may fix a fine in any amount not greater than $3,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of abuse of a corpse as charged in the presentment, then your verdict must be not guilty as to this offense. Count 20. Failure to report a death under suspicious, unusual, or unnatural circumstances. Any person who commits the offense of failure to report a death under suspicious, unusual, or unnatural circumstances is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following.
Yeah, but I'm wondering if on all the lion charges,
that the defendant knowingly failed to report the death of Evelyn Boswell to the county medical examiner, local police, district attorney, or sheriff. And 2, that the death was from violence, trauma, or any suspicious, unusual, or unnatural manner. For purposes of this count, knowingly is defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond reasonable doubt that the defendant is guilty of failure to report a death under suspicious, unusual, or unnatural circumstances, then you may fix a fine in any amount not greater than $3,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of failure to report a death under suspicious, unusual, or unnatural circumstances as charged in the presentment, then your verdict must be not guilty as to this offense. Criminal attempt. The following definition applies to the attempt to commit any criminal offense that is charged or included as a lesser offense in these instructions. Any person who attempts to commit any criminal offense is guilty of a crime. For you to find the person guilty of criminal attempt to commit any criminal offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specified criminal offense, and 2, that the defendant did some act intending to complete a course of action or cause a result that would constitute the specified criminal offense under circumstances as the defendant believed them to be at the time. And his actions constitute a substantial step toward the commission of the specified criminal offense. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit the specified criminal offense. The essential elements necessary to constitute each specified criminal offense are set out in these instructions. The definition of attempt to commit a criminal offense and the fine associated with each attempt to commit a criminal offense is as follows. Count 1. Attempt to commit premeditated first-degree murder, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $50,000. Attempt to commit voluntary manslaughter, maximum fine $50,000. Attempt to commit child abuse, maximum fine $50. Attempt to commit child neglect, maximum fine attempt to commit child abuse, maximum fine $500. Attempt to commit child neglect, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 2. Attempt to commit first-degree murder in the perpetration of a felony, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $25,000. Attempt to commit voluntary manslaughter, maximum fine $5,000. Attempt to commit child abuse, maximum fine $500. Attempt to commit assault,
Honey,
maximum
they can
fine
hang it up.
$500.
I've never seen any money from
Count
it.
3. Attempt to commit first-degree murder in the perpetration of a felony, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $25,000. Attempt to commit voluntary manslaughter, maximum fine $5,000. Attempt to commit child neglect, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 4. Attempt to commit aggravated child abuse, maximum fine $25,000. Attempt to commit aggravated assault, maximum fine $5,000. Attempt to commit maximum fine $500. Attempt to commit child abuse, maximum fine $500. Count 5. Attempt to commit aggravated child neglect, maximum fine $25,000. Attempt to commit aggravated assault, maximum fine $5,000. Attempt to commit assault, maximum fine $500. Attempt to commit child neglect, maximum fine $500. Count
And
6.
one of them, her middle
Attempt to
finger,
commit
no
tampering
less.
with evidence, maximum fine
Unbelievable.
$5,000. Counts 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17. Attempt to commit false report, maximum fine $5,000. Count 19, attempt to commit abuse of corpse, maximum fine $2,500. Count 20, attempt to commit failure to report death under suspicious, unusual, or unnatural circumstances, maximum fine $2,500. Facilitation of a felony. The following definition applies to any offense of facilitation that is charged or included as a lesser offense in these instructions. Any person who commits the offense of facilitation of a felony is guilty of a crime. For you to find the defendant guilty of facilitation of any offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that
I see
another
your
person
comment.
intended to commit the specified
Nobody
offense,
delete
but did not
Margaret's
have the intent to promote
comments
or assist the
if they're
commission
getting
of the
deleted.
offense
I
or to
see your
benefit
comments.
in the proceeds or results of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of the specified criminal offense. And 3, that the defendant furnished such assistance knowingly. The essential elements necessary to constitute the specified criminal offense are set out in these instructions. The definition of facilitation of an offense and the fine associated with each facilitation offense is as follows. Count 1, facilitation of first-degree murder, maximum fine $50,000. Facilitation of attempt to commit first-degree murder, maximum fine $25,000. Facilitation of second-degree murder, maximum fine $25,000. Facilitation of attempt to
I'm
commit
sorry,
second-degree
love.
murder,
It may be a
maximum fine $10,000.
YouTube thing.
Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminally negligent homicide, maximum fine $2,500. Count 2, facilitation of first-degree murder and the perpetration of a felony, maximum fine $50,000. Facilitation of attempt to commit first-degree murder and the perpetration of a felony, maximum fine $25,000. Facilitation of second-degree murder, maximum fine $25,000. Facilitation of attempt to commit second-degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminally negligent homicide, maximum fine $2,500. Count 3, facilitation of first-degree murder and the perpetration of a felony, maximum fine $50,000. Facilitation of attempt to commit first-degree murder and the perpetration of a felony, maximum fine $25,000. Facilitation of second-degree murder, maximum fine $25,000. Facilitation of attempt to commit second-degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminally negligent homicide, maximum fine $2,500. Count 4, facilitation of aggravated child abuse, maximum fine $5,000. Facilitation of attempt to commit aggravated child abuse, maximum fine $3,000. Facilitation of aggravated assault, maximum fine $5,000. Facilitation of attempt to commit aggravated assault, maximum fine $3,000. Facilitation of reckless aggravated assault, maximum fine $3,000. Count 5, facilitation of aggravated child neglect, maximum fine $5,000. Facilitation of attempt to commit aggravated child neglect, maximum fine $3,000. Facilitation of aggravated assault, maximum fine $5,000. Facilitation of attempt to commit aggravated assault, maximum fine $3,000. Facilitation of reckless aggravated assault, maximum fine $3,000. Count 6.
Oh, you know what? I feel sorry for that lady typing this.
Facilitation of
He
attempt
needs
to
to
commit
talk in
tampering with
fast.
evidence, maximum fine $3,000. Count 19. Facilitation of abuse of the corpse, maximum fine $2,500. Criminal responsibility for conduct of another. A defendant is criminally responsible as a party to the offense charged and included if the offense was committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense or to benefit in the proceeds or result of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. Under the theory of criminal responsibility, an individual's presence and companionship with the perpetrator of an offense before and after commission of an offense are circumstances from which his or her participation in the crime may be inferred. No particular act need be shown, and the defendant need not have taken a physical part in the crime in order to be held criminally responsible. However, a defendant's mere presence during the commission of a crime is not enough to convict based on the theory of criminal responsibility for the conduct of another. The jury is not required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by all the evidence in the case warrant the inference which the law permits the jury to draw. The inference may be rebutted by direct or circumstantial evidence or both, whether it exists in the evidence of the state or the evidence of the defendant. Before you can find the defendant guilty of being criminally responsible for an offense committed by the conduct of another, you must find that all the essential elements of the offense have been proven by the state beyond a reasonable doubt. Definitions. Intentionally or intent means a person acts intentionally with respect to the nature of the conduct or a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly or knew means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or the circumstances
I
exist.
did, but I take my own
The
shorthand.
person acts knowingly with respect to the result of the person's conduct
That's a
when the
fact.
person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown the defendant acted intentionally.
And then sometimes I
Recklessly
can't
or
make heads or
reckless means
tails
that a
out of
person acts
it.
recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown the defendant acted intentionally or knowingly. Adversely affect the child's health and welfare may include, but not limited to, the natural effects of starvation and dehydration. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, or any physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Child means a person under 18 years of age. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty, or a broken bone of a child who is 12 years of age or less. Cause of death. Before a defendant can be convicted of any degree of homicide, the state must have proven beyond a reasonable doubt that the death of the deceased was proximately caused by the criminal conduct of the defendant. The proximate cause of death is that cause which, in natural and continuous sequence, unbroken by any independent intervening cause, produces the death and without which the death would not have occurred. The defendant's conduct need not be the sole or immediate cause of death. The acts or omissions of two or more persons may work concurrently to proximately cause the death, and in such case, each of the participating acts or omissions is regarded as a proximate cause. It is not a defense that the negligent conduct of the deceased may have also been a proximate cause of the death. However, it is a defense to homicide if the proof shows the death was caused by an independent intervening act or omission of the deceased or another, which the defendant, in the exercise of ordinary care, could not reasonably have anticipated as likely to happen. However, if in the course of ordinary care, the defendant should reasonably have anticipated the intervening cause, that cause does not supersede the defendant's original conduct, and the defendant's conduct is considered the proximate cause of death. It is not necessary that the sequence of events or the particular injury be foreseeable. It is only necessary that the death fall within a general field of danger which the defendant should have reasonably anticipated. If you find that the defendant's act, if any, did not unlawfully cause or contribute to the death of the deceased, or if you have reasonable doubt as to this proposition, then you must find her not guilty. Deliberation process. Each count of the presentment is a separate offense, and you must deliberate on each count. When you begin your deliberations on each count of the presentment, you must first deliberate on the indicted or charged offenses. If you unanimously find the defendant guilty of the indicted offense, you may stop your deliberations as to that count of the presentment. You would then begin your deliberations as to the remaining counts of the presentment. If you unanimously find the defendant not guilty of the indicted offense in each count, or you have a reasonable doubt, then you must unanimously find the defendant not guilty of the indicted offense, and next consider the lesser included offenses in each count as set out below and in your verdict form. You must first deliberate on the greater offense as to each count and unanimously reach a verdict as to the greater offense before you move to the next lesser included offense within that particular count. If you unanimously reach a verdict as to the guilt of a defendant as to a greater offense, you may stop your deliberations as to that count. You would then proceed to the remaining counts of the presentment until you have reached a verdict on each count of the presentment. The order in which you are to consider the charges and lesser included offenses in each count is as follows. Count 1. 1. First degree murder. 2. Facilitation of first degree murder. 3. Attempt to commit first degree murder. 4. Facilitation of attempt to commit first degree murder. 5. Second degree murder. 6. Facilitation of second degree murder. 7. Attempt to commit second degree murder. 8. Facilitation of attempt to commit second degree murder. 9. Voluntary manslaughter. 10. Facilitation of voluntary manslaughter. 11. Attempt to commit voluntary manslaughter. 12. Facilitation of attempt to commit voluntary manslaughter. 13. Reckless homicide. 14. Facilitation of reckless homicide. 15. Criminally negligent homicide. 16. Facilitation of criminally negligent homicide. 17. Child abuse. 18. Child neglect. 19. Attempt to commit child abuse. 20. Attempt to commit child neglect. 21. Assault. 22. Attempt to commit assault. 23. Misdemeanor reckless endangerment. Count 2. 1, first-degree murder in the perpetration of a felony. 2, facilitation of first-degree murder in the perpetration of a felony. 3, attempt to commit first-degree murder in the perpetration of a felony. 4, facilitation of attempt to commit first-degree murder in the perpetration of a felony. 5, second-degree murder. 6, facilitation of second-degree murder. 7, attempt to commit second-degree murder. 8, facilitation of attempt to commit second-degree murder. 9, voluntary manslaughter. 10, facilitation of voluntary manslaughter. 11, attempt to commit voluntary manslaughter. 12, facilitation of attempt to commit voluntary manslaughter. 13, reckless homicide. 14, facilitation of reckless homicide. 15, criminally negligent homicide. 16, facilitation of criminally negligent homicide. 17, child abuse. 18, attempt to commit child abuse. 19, assault. 20, attempt to commit assault. 21, misdemeanor reckless endangerment. Count 3. 1, first-degree murder in the perpetration of a felony. 2, facilitation of first-degree murder in the perpetration of a felony. 3, attempt to commit first-degree murder in the perpetration of a felony. 4, facilitation of attempt to commit first-degree murder in the perpetration of a felony. 5, second-degree murder. 6, facilitation of second-degree murder. 7, attempt to commit second-degree murder. 8, facilitation of attempt to commit second-degree murder. 9, voluntary manslaughter. 10, facilitation of voluntary manslaughter. 11, attempt to commit voluntary manslaughter. 12, facilitation of attempt to commit voluntary manslaughter. 13, reckless homicide. 14, facilitation of reckless homicide. 15, criminally negligent homicide. 16, facilitation of criminally negligent homicide. 17, child neglect. 18, attempt to commit child neglect. 19, assault. 20, attempt to commit assault. 21, misdemeanor reckless endangerment. Count 4. 1, aggravated child abuse. 2, facilitation of aggravated child abuse. 3, attempt to commit aggravated child abuse. 4, facilitation of attempt to commit aggravated child abuse. 5, aggravated assault. 6, facilitation of aggravated assault. 7, attempt to commit aggravated assault. 8, facilitation of attempt to commit aggravated assault. 9, reckless aggravated assault. 10, facilitation of reckless aggravated assault. 11, assault. 12, attempt to commit assault. 13, misdemeanor reckless endangerment. 14, child abuse. 15, attempt to commit child abuse. Count 5. 1, aggravated child neglect. 2, facilitation of aggravated child neglect. 3, attempt to commit aggravated child neglect. 4, facilitation of attempt to commit aggravated child neglect. 5, aggravated assault. 6, facilitation of aggravated assault. 7, attempt to commit aggravated assault. 8, facilitation of attempt to commit aggravated assault. 9, reckless aggravated assault. 10, facilitation of reckless aggravated assault. 11, assault. 12, attempt to commit assault. 13, misdemeanor reckless endangerment. 14, child neglect. 15, attempt to commit child neglect. Count 6. 1, tampering with evidence. 2, facilitation of tampering with evidence. 3, attempt to commit tampering with evidence. 4, facilitation of attempt to commit tampering with evidence. Count 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17. 1, false report. 2, attempt to commit false report. Count 19. 1, abuse of a corpse. 2, facilitation of abuse of a corpse. 3, attempt to commit abuse of a corpse. 4, facilitation of attempt to commit abuse of a corpse. Count 20. 1, failure to report a death under suspicious, unusual, or unnatural circumstances. And 2, attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances. The essential elements for each offense of each count of the presentment have been previously set forth in these instructions. Please refer to those essential elements as you deliberate on the charged offense or lesser included offense of each count of the presentment. Fines. Excuse me. If you find the defendant guilty beyond reasonable doubt of an offense, you may, in your discretion, fix a fine in any amount not to exceed the amount listed for that offense in these instructions and on the verdict forms. If after considering the charged offense and lesser included offenses in each count as set out above and in the verdict form, you find the defendant not guilty or have a reasonable doubt as to her guilt as to all counts and offenses, then you must return a verdict of not guilty and acquit the defendant. In considering the charged offense and lesser included offenses in each count, in this case, do not consider punishment. If you find the defendant guilty of any offenses of any count, the court will set punishment at a separate sentencing hearing. Y'all want to come up here for a second?
Oh my God, always. Wow. Yeah, life can change in a matter of seconds. I always say, in the blink of an eye, you never know. Well, if it's any consolation to you, when my first baby was little, my husband was riding what was it? I can't remember now if it was I think it was I don't know if it was a motorcycle or I'll have to ask him. I can't remember. I have all this stuff in my brain, but Jesus. Anyway, he used to work at Howard's Honda out there in Nashville. And they let him bring the stuff home, the toys, all the toys. And he ran over the cab. The cab didn't run over him. He was coming out of the yard. Pew! And he broke his leg from toe all the way up, honey, to his private area. And he was laid up forever and a day.
Now, ladies and gentlemen, remember, when you go back there and you select a four-person, this is the official jury charge, okay? And I'm not going to take up your books and make a change in every one of your books and hand them back out. Otherwise, we'd be here till later tonight. So I'm going to make the change on page 48. And when you deliberate, you go by what this black notebook says. Can everybody do that? Everybody's shaking their head yes. All right. Let me start that over. If after your deliberations you find the defendant guilty of first-degree murder, we will then proceed to sentencing and you will set the punishment. If you find the defendant guilty of any offense in counts 4 through 20, the court will set the punishment at a separate sentencing hearing. You'll be provided with forms for all possible verdicts in this case, and it will be at the back of these instructions. The jury, the jury will mark the appropriate verdict on the form by checking the box next to your verdict, and your foreperson will sign and date the verdict form. Now, in your books, you don't have, you may have. You have verdict forms? All right. This goes back to what I said about the original notebook. You use the verdict forms in this black notebook. All right. Verdict form count 1. We, the jury, find the defendant, Megan Boswell, mark the appropriate 1. Checkbox 1, guilty of first-degree murder. Or checkbox 2, guilty of facilitation of first-degree murder. Fine amount $ blank, not more than $50,000. Or checkbox 3, guilty of attempt to commit first-degree murder. Fine amount $ blank, not more than $50,000. Or checkbox 4, guilty of guilty of facilitation of attempt to commit first-degree murder. Fine amount $ blank, not more than $25,000. Or checkbox 5, guilty of second-degree murder. Fine amount $ blank, not more than $50,000. Or checkbox 6, guilty of facilitation of second-degree murder. Fine amount $ blank, not more than $25,000. Verdict form, count 1 continued. Checkbox 7, guilty of attempt to commit second-degree murder. Fine amount $ blank, not more than $25,000. Or checkbox 8, guilty of facilitation of attempt to commit second-degree murder. Fine amount $ blank, not more than $10,000. Or checkbox 9, guilty of voluntary manslaughter. Fine amount $ blank, not more than $10,000. Or checkbox 10, guilty of facilitation of voluntary manslaughter. Fine amount $ blank, not more than $5,000. Or checkbox 11, guilty of attempt to commit voluntary manslaughter. Fine amount $ blank, not more than $5,000. Or checkbox 12, guilty of facilitation of attempt to commit voluntary manslaughter. Fine amount $ blank, not more than $3,000. Or checkbox 13, guilty of reckless homicide. Fine amount $ blank, not more than $5,000. Or checkbox 14, guilty of facilitation of reckless homicide. Fine amount $ blank, not more than $3,000. Excuse me. Or verdict form count 1 continued. Checkbox 15, guilty of criminally negligent homicide. Fine amount $ blank, not more than $3,000. Or checkbox 16, guilty of facilitation of criminally negligent homicide, fine amount $ blank, not more than $2,500, or checkbox 17, guilty of child abuse, fine amount $ blank, not more than $2,500, or checkbox 18, guilty of child neglect, fine amount $ blank, not more than $2,500, or checkbox 19, guilty of attempt to commit child abuse, fine amount $ blank, not more than $500, or checkbox 20, guilty of attempt to commit child neglect, fine amount $ blank, not more than $500, or checkbox 21, guilty of assault, fine amount $ blank, not more than $2,500, or checkbox 22, guilty of attempt to commit assault, fine amount $ blank, not more than $500, or verdict form count 1 continued. Checkbox 23, guilty of misdemeanor reckless endangerment, fine amount $ blank, not more than $2,500, or checkbox 24, not guilty, 4-person signature line date blank. Verdict form count 2, with jury find the defendant Megan Boswell marked appropriate 1, checkbox 1, guilty of first degree murder in the perpetration of a felony, or checkbox 2, guilty of facilitation of first degree murder in the perpetration of a felony, fine amount $ blank, not more than $50,000, or checkbox 3, guilty of attempt to commit first degree murder in the perpetration of a felony, fine amount $, blank, not more than $50,000, or checkbox 4, guilty of facilitation of attempt to commit first degree murder in the perpetration of a felony, fine amount $, blank, not more than $25,000, or checkbox 5, guilty of second degree murder, fine amount $, blank, not more than $50,000, or verdict form count 2 continued, checkbox 6, guilty of facilitation of second degree murder, fine amount $ blank, not more than $25,000, or checkbox 7, guilty of attempt to commit second degree murder, fine amount $ blank, not more than $25,000, or checkbox 8, guilty of facilitation of attempt to commit second degree murder, fine amount $ blank, not more than $10,000, or checkbox 9, guilty of voluntary manslaughter, fine amount $ blank, not more than $10,000, or checkbox 10, guilty of facilitation of voluntary manslaughter, fine amount $ blank, not more than $5,000. Checkbox 11, or checkbox 11, guilty of attempt to commit voluntary manslaughter, fine amount $ blank, not more than $5,000, or checkbox 12, guilty of facilitation of attempt to commit voluntary manslaughter, fine amount $ blank, not more than $3,000, or checkbox 13, guilty of reckless homicide, fine amount $ blank, not more than $5,000, or verdict form count 2 continued. Checkbox 14, guilty of facilitation of reckless homicide, fine amount $ blank, not more than $3,000, or checkbox 15, guilty of criminally negligent homicide, fine amount $ blank, not more than $3,000, or checkbox 16, guilty of facilitation of criminally negligent homicide, fine amount $ blank, not more than $2,500, or checkbox 17, guilty of child abuse, fine amount $ blank, not more than $2,500, or checkbox 18, guilty of attempt to commit child abuse, fine amount $ blank, not more than $500, or checkbox 19, guilty of assault, fine amount $ blank, not more than $2,500, or checkbox 20, guilty of attempt to commit assault, fine amount $ blank, not more than $500, or verdict form count 2 continued. Checkbox 21, guilty of misdemeanor reckless endangerment, fine amount $ blank, not more than $2,500, or checkbox 22, not guilty, 4-person signature line date blank. Verdict form count 3, we the jury find the defendant Megan Boswell marked the appropriate 1, checkbox 1, guilty of first degree murder and perpetration of a felony, or checkbox 2, guilty of facilitation of first degree murder and perpetration of a felony, fine amount $ blank, not more than $50,000, or checkbox 3, guilty of attempt to commit first degree murder and perpetration of a felony, fine amount $ blank, not more than $50,000, or checkbox 4, guilty of facilitation of attempt to commit first degree murder in the perpetration of a felony, fine amount $ blank, not more than $25,000, or checkbox 5, guilty of second degree murder, fine amount $ blank, not more than $50,000, or verdict form count 3 continued. Checkbox 6, guilty of facilitation of second degree murder, fine amount $ blank, not more than $25,000, or checkbox 7, guilty of attempt to commit second degree murder, fine amount $ blank, not more than $25,000, or checkbox 8, guilty of facilitation of attempt to commit second degree murder, fine amount $ blank, not more than $10,000, or checkbox 9, guilty of voluntary manslaughter, fine amount $ blank, not more than $10,000, or checkbox 10, guilty of facilitation of voluntary manslaughter, fine amount $ blank, not more than $5,000, or checkbox 11, guilty of attempt to commit voluntary manslaughter, fine amount $ blank, not more than $5,000, or checkbox 12, guilty of facilitation of attempt to commit voluntary manslaughter, fine amount dollar sign blank, not more than $3,000, or checkbox 13, guilty of reckless homicide, fine amount dollar sign blank, not more than $5,000, or verdict form count 3 continued. Checkbox 14, guilty of facilitation of reckless homicide, fine amount dollar sign blank, not more than $3,000, or checkbox 15, guilty of criminally negligent homicide, fine amount dollar sign blank, not more than $3,000, or checkbox 16, guilty of facilitation of criminally negligent homicide, fine amount dollar sign blank, not more than $2,500, or checkbox 17, guilty of child neglect, fine amount dollar sign blank, not more than $2,500, or checkbox 18, guilty of attempt to commit child neglect, fine amount dollar sign blank, not more than $500, or checkbox 19, guilty of assault, fine amount dollar sign blank, not more than $2,500, or checkbox 20, guilty of attempt to commit assault, fine amount dollar sign blank, not more than $500, or verdict form count 3 continued. Checkbox 21, guilty of misdemeanor reckless endangerment, fine amount dollar sign blank, not more than $2,500, or checkbox 22, not guilty for signature line date blank. Verdict form count 4, we the jury find the defendant Megan Boswell, mark appropriate 1. Checkbox 1, guilty of aggravated child abuse, fine amount dollar sign blank, not more than $50,000, or checkbox 2, guilty of facilitation of aggravated child abuse, fine amount dollar sign blank, not more than $25,000, or checkbox 3, guilty of attempt to commit aggravated child abuse, fine amount dollar sign blank, not more than $25,000, or checkbox 4, guilty of facilitation of attempt to commit aggravated child abuse, fine amount dollar sign blank, not more than $10,000, or checkbox 5, guilty of aggravated assault, not more than, fine amount dollar sign blank, not more than $10,000, or checkbox 6, guilty of facilitation of aggravated assault, fine amount dollar sign blank, not more than $5,000, or verdict form count 4 continued. Checkbox 7, guilty of attempt to commit aggravated assault, fine amount dollar sign blank, not more than $5,000, or checkbox 8, guilty of facilitation of attempt to commit aggravated assault, fine amount dollar sign blank, not more than $3,000, or checkbox 9, guilty of reckless aggravated assault, fine amount dollar sign blank, not more than $5,000, or checkbox 10, guilty of facilitation of reckless aggravated assault, fine amount dollar sign blank, not more than $3,000, or checkbox 11, guilty of assault, fine amount dollar sign blank, not more than $2,500, or checkbox 12, guilty of attempt to commit assault, fine amount dollar sign blank, not more than $500, or checkbox 13, guilty of misdemeanor reckless endangerment, fine amount dollar sign blank, not more than $2,500, or checkbox 14, guilty of child abuse, fine amount dollar sign blank, not more than $2,500, or verdict form count 4 continued. Checkbox 15, guilty of attempt to commit child abuse, fine amount dollar sign blank, not more than $500, or checkbox 16, not guilty, 4-person signature line date blank. Verdict form count 5, we the jury find the defendant Megan Boswell, mark the appropriate 1. Checkbox 1, guilty of aggravated child neglect, fine amount dollar sign blank, not more than $50,000, or checkbox 2, guilty of facilitation of aggravated neglect, fine amount dollar sign blank, not more than $25,000, or checkbox 3, guilty of attempt to commit aggravated child neglect, fine amount dollar sign blank, not more than $25,000, or checkbox 4, guilty of facilitation of attempt to commit aggravated child neglect, fine amount dollar sign blank, not more than $10,000, or checkbox 5, guilty of aggravated assault, fine amount dollar sign blank, not more than $10,000, or checkbox 6, guilty of facilitation of aggravated assault, fine amount dollar sign blank, not more than $5,000. Verdict form count 5 continued. Checkbox 7, guilty of attempt to commit aggravated assault, fine amount dollar sign blank, not more than $5,000, or checkbox 8, guilty of facilitation of attempt to commit assault, aggravated assault, fine amount dollar sign blank, not more than $3,000, or checkbox 9, guilty of reckless aggravated assault, fine in amount dollar sign blank, not more than $5,000, or checkbox 10, guilty of facilitation of reckless aggravated assault, fine amount dollar sign blank, not more than $3,000, or checkbox number 11, guilty of assault, fine in amount of dollar sign blank, not more than $2,500, or checkbox 12, guilty of attempt to commit assault, fine amount dollar sign blank, not more than $500, or checkbox 13, guilty of misdemeanor reckless endangerment, fine amount dollar sign blank, not more than $2,500, or checkbox 14, guilty of child neglect, fine amount dollar sign blank, not more than $2,500, or verdict form count 5 continued. Checkbox 15, guilty of attempt to commit child neglect, fine amount dollar sign blank, not more than $500, or checkbox 16, not guilty, 4-person signature line date blank. Verdict form count 6, we the jury find the defendant Megan Boswell, mark the appropriate 1. Checkbox 1, guilty of tampering with evidence, fine amount dollar sign blank, not more than $10,000, or checkbox 2, guilty of facilitation of tampering with evidence, checkbox, the amount dollar sign blank, not more than 5,000, or checkbox 3, guilty of attempt to commit tampering with evidence, fine, amount dollar sign blank, not more than 5,000, or checkbox 4, guilty of facilitation of attempt to commit tampering with evidence, fine, amount dollar sign blank, not more than 3,000, or checkbox 5, not guilty, 4-person signature line date blank. Verdict form counts 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17. We, the jury, find the defendant, Megan Boswell, marked the appropriate 1. Checkbox 1, guilty of false report, fine, amount dollar sign blank, not more than 5,000, or checkbox 2, guilty of attempt to commit false report, fine, amount dollar sign blank, not more than 3,000, or checkbox 3, not guilty, 4-person signature line date blank. Verdict form count 19. We, the jury, find the defendant, Megan Boswell, marked the appropriate 1. Checkbox 1, guilty of abuse of corpse, fine, amount dollar sign blank, not more than $3,000, or checkbox 2, guilty of facilitation of abuse of a corpse, fine, amount dollar sign blank, not more than $2,500, or checkbox 3, guilty of attempt to abuse a corpse, fine, amount dollar sign blank, not more than $2,500, or checkbox 4, guilty of facilitation of attempt to commit abuse of corpse, fine, amount dollar sign blank, not more than $500, or checkbox 5, not guilty, 4-person signature line date blank. Verdict form count 20. We, the jury, find the defendant, Megan Boswell, marked the appropriate 1. Checkbox 1, guilty of failure to report a death under suspicious, unusual, or unnatural circumstances, fine, amount dollar sign blank, not more than 3,000, or checkbox 2, guilty of attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances, fine, amount dollar sign blank, not more than 2,500, or checkbox 3, not guilty, 4-person signature line date blank. Back on page 48. You'll be provided with, well, I just did that. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. If you find the state has proven the defendant guilty beyond a reasonable doubt, then you should find her guilty. On the other hand, if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to her guilt, then you must find the defendant not guilty. I'm going to stop right there. Is there lunch here? Your lunch is here. I'm going to let you go eat. I want you to take your notebooks and sit them on your chair and leave them out here. I'm going to have you go with the officer, eat lunch. When we come back, the parties will argue, then I will finalize the charge.
Everyone stand, please.
I know. I know.
So we need to address that.
Okay. You need to plan up your table. You don't want me to stand right here?
I don't want you to cross.
I may stand right here.
Stop you from standing right there. I'm gonna stand in front of you, but I don't want you to cross the face.
Why?
My face.
Judge, we may have to have a sidebar before we start.
Not what I said. Just quick approach.
Those of you stand on the back wall. I can see.
I'm here. I'm turning my music off. Hold on a minute. Justin said we don't have to have it on court TV. Yay, that's why it was silent earlier. Let me turn my TV, my phone off. It gets confusing working all these devices, y'all.
The problem is that laser generator, because it's made for LCD screens, the sound off.
Okay, and the reason why about the music earlier is because Court TV earlier this morning they had on music too, and it was pretty loud. So Justin told me I didn't have to have mine on also because Court TV didn't care about it, and then I turned mine off, and Court TV had theirs off as well. So we didn't have no music for a little bit. Y'all, I'm still having my tropical smoothie from yesterday,
All right.
and it's frozen to death.
Is the state ready to proceed with closing?
Yes, Your Honor.
Defense ready?
Welcome
Yes,
back,
sir.
everyone.
If the jury's ready, let's bring them in.
Thank you for being here. Love
Now, I'm
y'all.
going to say,
Appreciate
hey, Kyle,
you.
hold on.
Okay.
Good afternoon. Thank you for being here.
Sorry.
We're back.
We put this down here so y'all can hear me. Can everybody hear me? If there's any outbursts at any time during the state's closing, the defendant's closing,
Honey, he gets in
state's
a
rebuttal,
mood
I'll clear the whole courtroom.
after lunch, don't he? He should be in a better mood
Right.
after lunch.
Now we have the jury.
I think it's the opposite for him. He gets more grumpy after lunch. Maybe he wants to take a nap. I appreciate you, Janice. I appreciate all of you.
You've got exhibits 1 through 5 and 93. Separated, right? 93 also? Okay.
I need exhibit number 183. It's a video.
It's
I
bad
don't
for
guess
the
Mr.
security.
Scott needs to watch Court
Huh?
TV anymore, huh?
Blood sugar lung. Get rid of all Everyone stand, please.
Uh-oh, what just happened? Smiley didn't touch no buttons. Hey, Kimberly, what is going on? Nope. Let me. Mm-mm.
Reflect on some of the witnesses because it's been a pretty long, almost 2 weeks. The state will go first, then one of the defense attorneys will have an opportunity to go, then the state will go again. And Matt, I'll talk a little more about that in a second, but that's because the state carries the burden of proof. So I think each of you should have a jury instruction pamphlet in front of you. I'm going to ask you if you flip to page number 6.
They're going first because they have the burden of proof.
It covers the burden of proof.
Oh, Smiley's here, honey.
And it seems like it's a common misnomer for the burden of proof to appear to be higher than it actually is for the state of Tennessee. And don't get me wrong, it is a high burden, and we gladly carry that burden every step of the way. But when you read about reasonable doubt, and that, of course, the burden never shifts to the defense. The burden is always on the state of Tennessee. It is a burden. It's not absolute certainty. It does not require you to say, I don't know 100% what happened. That is not what is required by the law. It is not absolute certainty. It's essentially, can you go to bed and let your mind rest easy? Can you, actually, I'm going to do one other thing real quick. What I'm asking you to do is essentially use your own common sense. That's one of the most important things. Okay. And I'm going to give an example of what I mean by this, if I can. It's like Wheel of Fortune. Okay. My handwriting's not the best though. But you get the idea here. It's like Wheel of Fortune. When you see a contestant on Wheel of Fortune and they know the answer to the phrase or the statement, they don't have all the letters when they see that phrase, but they know what the answer is. And if the state has done that, we have met our burden. And it's important to note that it's not beyond a shadow of a doubt. It's not absolute certainty. That is not what is required by the law, by the state of Tennessee. So that brings me to some of the arguments that Mr. Scott has made through this trial. They might be on that same page. Probably should have written it. Here it is, page 5. In your instructions, in the second paragraph, it states, statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. And I beg you to remember that. When Mr. Scott gets back up and makes his arguments, remember that. The things that come out of his mouth and that came out of his mouth during trial, that is not the evidence. He tried to get you to speculate on so many things during this trial. He wanted to throw out strange theories with aluminum foil. He wanted to throw out a term that doesn't even matter anymore, SIDS. That came from his mouth, not either of the doctors, but from Mr. Scott. He's asking you to speculate. That is not evidence. I beg you to only think about the items that were put into evidence, the photographs, the recordings, and what came from the witness stand. Do not let them sway you from what actually happened in this case. He kept mentioning cadaver dogs. He wanted you to think about that. But if you remember the cadaver dogs, Tommy Boswell, on his property, what did we hear him say? The cadaver dogs didn't even go up there by the playhouse. He wants you to believe maybe the body wasn't there at that time. He's trying to throw you off, but he didn't show anything. There's no proof. There's no evidence.
We are not even going to get through a freaking closing with the state.
Ladies and gentlemen, I want to remind you once again, and it's in here in these instructions, but the defendant has no burden to prove anything during this trial. The burden is wholly on the state of Tennessee. Okay? Go ahead, John.
Thank you. And I believe I said that. The state, we gladly carry this burden. But again, what comes out of Mr. Scott's mouth is not evidence. You heard nothing from the witness stand about cadaver dogs. There's no piece of evidence about cadaver dogs. And Mr. Scott said in his opening statement, humans make mistakes. Do you remember that? Dogs also can make mistakes. And if you remember, Agent Fraley and Agent Gratz, both with the TBI, what did they say? They didn't smell anything in that playhouse until they lifted the black bag, and immediately the smell of decomposition hit them. I submit to you, cadaver dogs, what do they work off of? The smell of decomposition. Don't let that fool you. Mr. Scott also talked a lot about Hunter Wood. We heard a lot about Mr. Wood in this trial. Again, did we hear any witness from the witness stand that ever saw Evelyn with Hunter Wood? There wasn't a witness that ever saw Evelyn with Hunter Wood. And if you remember the text messages that we saw yesterday from essentially Hunter's own mouth, it's pretty clear that he's yet another victim of Megan Boswell. She was feeding him the same lines that she was feeding every other person in this case.
Thank you.
Mr. Scott brought up the theory of an accident or the word SIDS. Well, you heard Dr. Malushnik say that in the past 10 years in the state of Tennessee, a child 12 months or older has not passed away from SIDS or sudden unexplained death. Those are statistics from the state of Tennessee. But somehow Mr. Scott wants you to believe that somehow that's how this baby died, even though she has foil wrapped around her head, a blanket wrapped around that, inside a trash bag, upside down in a trash can. Let's go through our timeline just for a minute. What do we know? We know that Evelyn was okay until November of 2019. We know that Evelyn was seen at Thanksgiving by family. And then Megan Boswell started a new job at the Chicken Shack. What do we know after that? Megan Boswell meets Hunter Wood. And we know that Sue Whitson is probably the last person to ever see Evelyn alive again. You remember the picture that Sue took? This is very likely the very last picture of Evelyn Boswell alive. Not taken by Megan Boswell, but taken by the babysitter. Sue Whitson testified that the last time she babysat was the end of November, early December, which just so happened to coincide with when Megan Boswell met Hunter Wood, a guy that she was hoping might change her life. But Evelyn was in the way. What did we hear? Do you remember Megan's friend, Maddie Broom? We heard a little bit about her. Her brother, Stephen Lawrence, tried to help Megan. She drove her to a few of the interviews. And if you remember, Megan was apartment shopping on December 8th. And on that date, Evelyn was not with her. And so Stephen asked her later, after it's been reported that Evelyn's missing, he says, was Evelyn gone by then? And what did Megan say? Yes, Evelyn was gone by then. So that takes our window from December 3rd, essentially when Megan Boswell started working at the Chicken Shack, to December 8th. Evelyn Boswell's 12-month well visit. Do you remember that? Scheduled for December 5th. Megan doesn't call and cancel. She just no-shows.
They're doing closing arguments.
Casey Saltz, the receptionist there, had to reach out and ask Megan, and Megan gave some excuse. I can't remember what it was, as to why she couldn't bring her. So they rescheduled for the next day. Did Megan show up with Evelyn the next day? No, she didn't. I submit to you, that's because Evelyn was already gone at that point. Casey texts Megan again, and Megan has yet another excuse. The appointment's rescheduled one more time for December 11th, and conveniently, Megan then says, oh, I've decided to change pediatricians. And as we can all imagine, when you change pediatricians, we all know that children have vaccine records and all of the things that come with being, especially that first 12 months of life. They've got a lot of appointments and a lot of vaccinations. So it'd be really, really important to transfer that information to the new pediatrician. Did Megan Boswell do that? No, she didn't. They never got a request from another pediatrician. That was just another line that Megan Boswell told to start trying, I say trying, to cover her tracks. We also know that on December 7th, you saw a text message yesterday from a girl named Haley Marie, and that is the very first time that Megan tells the story her dad has her. December 7th. Keep in mind, Sue Whitson saw Evelyn alive for the last time, and then Megan just stopped showing up. And then by December 7th, she's concocted her plan. And it really explains why so much time goes by. Because I know that's a question we have all had. 2.5 months goes by. 2.5 months. But now we know. We know why. Because Megan Boswell was telling every single person in her family and her closest friends that Evelyn was with her father. So what does a rational person think? Okay, we're glad. I think Tommy even said that from the stand. I was proud of him for stepping up. I was proud of him for stepping up and taking responsibility. But, time continues to pass, and you've heard witnesses, and particularly Bailey and Audrey, Megan's closest friends. They were all starting to talk and to think that something doesn't feel right. It just doesn't feel right. But no one could have known how wrong this was at the time. February 2020, finally, Tommy Boswell says, I've had enough. I want to see my granddaughter. Show her to me by tomorrow, or I'm reporting it to DCS. Well, Megan couldn't do that. Megan knew she couldn't do that. because she knew where Evelyn was. We all know where Evelyn was. And so Megan did not produce Evelyn that day. And Tommy finally gets the ball rolling on trying to find this little girl. And they first show up at Hunter Wood's house on the lake in a nice neighborhood. And Megan Boswell's there. But there's no baby. There's no Evelyn. And you remember, the only thing Megan, you remember James Lewis from DCS, the only thing Megan was really able to show was this box from Hunter's bedroom. And you remember what Megan called that box? A memory box. Now, why would you call something a memory box if you are alleging that your child is still alive? This is all Megan Boswell had of Evelyn in that house that she was trying to show DCS that Evelyn was living in. She couldn't show him diapers. She couldn't show him a pack and play. She showed him one outfit that she held up on a hanger, not an outfit that Evelyn had ever worn. There was no evidence that a child had ever been in that house. Now, I'm going to touch on something briefly. If you remember Paul Durant yesterday, going back and trying to just give you a little bit of a timeline. If you remember, he talked about Ethan Perry in the military because Megan Boswell led him to believe that he was the father, even though he had his doubts. She convinced him that he was the father of Evelyn. We know he was not the father. We know that. And he said she was sharing photos daily, constantly sharing photos. Until what day? Do you remember the date? December 3rd. On December 3rd, Megan Boswell stopped sharing photographs of Evelyn. And she continues to send pictures, but if you remember, Agent Durant he's a smart guy. And so he was able to check her full Facebook extraction. And so she continued to send pictures to Ethan, but they weren't recent pictures. It was just another way that she could try to keep this facade going just as long as she could. You to believe that Megan Boswell had a rough life. She was in foster care. But Megan Boswell was in foster care because of Megan Boswell. Because she would not go
And
to
not
school.
till she was
She went to
almost
foster
grown.
care because she was truant. And when she left foster care, she went and lived with her dad. And of course, Evelyn was a baby at this point. I think the testimony was from February to March of 2019. And then her dad said, I'm going to get her a trailer, set her up. He bought her a brand new car, buys her a trailer. He's giving her everything she needs to raise this child. And she goes and lives with Omami, her grandmother, from April until October of 2019. And then finally into the trailer from October to December. I think it's fair to say that she did not live in that trailer with Evelyn for very long. But in that short period of time, this is what she was able to do to that trailer. Can we look at that for a second? That's what she had her child living in. If that's not neglect, she does this in 2 months. Ladies and gentlemen, I beg you to look at these pictures when you go back in the jury room. That, in 2 months, is what the defendant was able to do to the home her dad provided for her and her child. And within 2 months, Evelyn was dead. And I stated maybe it's just my opinion, there are a lot of victims in this case. Bailey Hawkins, her very best friend. Did you see how difficult it was for Bailey to testify? To look at someone that she trusted, that she loved. Audrey Gibbs, same thing. They are also victims of Megan Boswell. And they will also suffer for the rest of their lives because of what Megan Boswell, the web that she created for them all to get caught in. Erica Stacy, who cared about Megan and Evelyn so much, is a victim. Gail Kite, the foster mother, she's a victim. Ethan Perry, who's serving his country, doing absolutely nothing other than his job, gets pulled up into Megan Boswell's web because Megan Boswell is only worried about Megan Boswell. And I'll submit to you that Hunter Wood, the person that they would like to blame somehow, is also a victim of Megan Boswell. She starts with first blaming Ethan Perry. She does that for a few days. And when she quickly realizes, gosh, law enforcement can figure out that I'm not telling the truth here, I guess I better tell something different. Then she goes to her mom. She blames her mom, her own mother. She's willing to blame all the time knowing. I mean, we know, let's find the picture. We know where Evelyn was. How about that Megan Boswell is the one who drove her own vehicle, the vehicle her dad bought for her, up to that shed because Megan Boswell is the one who had a key fob. Remember, there's a gate there that only opens with a key fob. That's the only way a car is coming through that driveway. And Megan Boswell lived there. You just heard that she lived at her dad's house and at Omami's house. And so they're not going to be surprised if Megan Boswell is on the property. She's the one who dumped Evelyn's property there. She's the one who took the trash can there. Not Hunter, not anyone else. It's Megan Boswell. Do you remember there was more than one text message? And of course, keep in mind, the whole time these text messages are coming through, that's where Evelyn is, okay? Just think about that for a second. I'm not going to take the time to go through these because you can do that. You can take all of this back with you into the jury room. I encourage you to go back and read all of these text messages and remember the dates that we've talked about. But while Evelyn Boswell is sitting in this trash can and people are asking Megan, how's Evelyn? What does Megan say more than once? Mean as fuck. First of all, she's a 12-month-old child. And every other witness said that she was a lovely child to be around. And that's
My God.
it's not a very nice statement to begin with.
Right,
But it's
right.
definitely not a very nice statement when your kid is shoved down into a trash can upside down. And you know that. Agent Fraley was on the stand, and you heard Megan Boswell admit that she knew Evelyn was dead. Where she's telling all of those stories to law enforcement. And she told more than one person, Evelyn's mean as fuck. And when Agent Grass asked her about it, she goes, "What's your point? What's your point?" And that's an interview with Agent Grass that you can also go back and watch if you'd like to do that. So we saw the defendant enjoyed crying during this trial because she has an audience and she really enjoys that. But did we see her crying any other time? Did we see her crying from the witnesses on the witness stand and what they told us about her? Did we see her crying in the evidence that came in? No, Megan wasn't crying. Do you think she was crying when she filled out this apartment application with Hunter Wood, where they list 3 occupants are going to live in the apartment? And at first glance, we're like, oh, Megan, Hunter, and Evelyn. But that's not what the defendant told David Gratz. Do you remember what she told him? She said the 3rd occupant is the baby she's pregnant with because Hunter doesn't want Evelyn to live with him. Of course, we could also look at the date on that application, January 4th of 2020. And we also know another reason that Evelyn would not be living with them. Was Megan crying here? In 2020, when she posts on Instagram, so excited for our new home. Think Megan was crying when she posted that? To me, it looks like maybe Megan's just moving on with her life. As if Evelyn never even existed. What about here? Also posted in 2020. Keep in mind, Evelyn's still upside down in a trash can because Megan's not told anyone where she is. She's still spinning her lies. Do you think she sat here when she's picking out furniture for their new house? That she's sad today? She has the gall to sit here and cry today? And pretend she can't look at the pictures of what she did to her child? What about this one? Proud of my baby. New 2020 High Country. Was she sad then? What about in December? Weeks after Evelyn has been brutally murdered. What is Megan Boswell doing? Does she look, maybe we should zoom in. Does she look sad here? Maybe she is. Sure doesn't look like it. Her kid's upside down in a trash can. She's going to the aquarium with her new boyfriend. What about here? She doesn't look very sad to me. Hiking in Blowing Rock in 2020. No Evelyn. Evelyn's missing. Still missing at this time. There's Megan hiking with her new boyfriend, moving on with her life. Not crying. Maybe Megan Boswell didn't have an end game. Maybe she didn't know. Maybe she hoped that Evelyn would never be found. But she had to know at some point these stories were going to catch up with her. Ladies and gentlemen, and I'm asking you today, 5 years later, February 2025, to show Megan Boswell that her stories have caught up with her. The evidence shows the defendant. This person is the only person responsible for her child being dead. You heard it straight from Dr. Malushnik. Evelyn shouldn't be dead. Evelyn should not be dead. I believe the defense brought up SIDS, reflux, rollover. I believe they even brought up a tongue tie as being a possible cause of death for Evelyn. How does that result? Any of those things? You know, he said in the beginning, the state can't even prove how she died. Are you kidding me? How does that end up with a baby in a trash can? The DNA. Let's talk about the DNA for a second. You've got the gloves that are in the trash can. And the defense somehow wants you to believe that gloves will keep fingerprints from happening. And then I guess whoever did that then took the gloves off, cut them up because they're cut up in small pieces and you can look at them when you get back there, and then dispose of them in the same trash can that the baby's in. That doesn't make sense. That doesn't make sense. And funny enough, guess what is there? Is DNA that matches Megan Boswell, that matches Evelyn. Go back through the testimony. There's not one piece of DNA, not one, that shows anyone, not Hunter Wood, not anyone else other than Megan Boswell is associated with that trash can, the evidence in the trash bags. And you heard Marla Gray, the DNA expert, talk about the mixture of DNA on some pillows that were found in the shed. And you also heard her say that that could even be from the person who made them in the factory. Or it could be from the person who touched the pillow at Walmart when they were trying to decide if they were going to buy it. It wasn't even enough DNA to test. So don't be led to believe that because of that, there's some unknown stranger who did these things. Look at the evidence. Look at the evidence that's in front of you. We have evidence. We have shown you the evidence. Don't think about the speculation. Don't think about the what ifs. Look at the evidence. Some really, really good. If I could, can I see the trash can for just a second, please? Thank you. Whose fingerprints were on the trash can? Do you remember what Agent Hoover said from the TBI yesterday? Of course, he's removed the rim. He talked about how it's smooth under the rim. If you're going to carry a trash can, how do you pick it up to carry it under the rim? Whose fingerprints were under that rim? Megan Boswell. Megan Boswell's fingerprints were under that rim. If we look at Exhibit 17, can you see the black trash bag there? Whose fingerprints are on that trash bag?
She just made
Megan Boswell's fingerprints.
Hey.
And you heard Dr. Malushnik say, and I think you can see for yourself, that trash bag's not just gently placed down into the trash can. It has been forcefully, and it's a hard image. It's a very difficult image to think about. But that's the evidence that we've been left with, that black trash bag was placed on top of Evelyn in the white trash bag. And it was forcefully pushed down. Compressed, I think is a word that was used during the trial. And that's how Megan Boswell's fingerprints ended up on that black trash bag.
I said she may pull out all the stops today.
Even more damning than that is the fact that Megan Boswell's fingerprints are on the foil wrapped around Evelyn's head. I would love to know a different explanation for how Megan Boswell's fingerprints got on the foil, on that trash can, on the black trash bag, except for the fact that she murdered her baby. She put her in that trash can with food trash and debris, covered her body, essentially mummified her, and tossed her away, literally, with the trash. Mr. Scott would like for you to think that the doctor's testimony, just that they shouldn't be able to just decide things in a vacuum. He kept mentioning, well, what if a child's dead on a table? And I think we all know that is not how doctors operate. Doctors operate off of medical histories and any information they can get. And that's what both doctors did in this case. They took everything, her birth records, her pediatric records, the scene itself, before they came to their conclusion. They don't operate in a vacuum. I think those were the words that Dr. Malushnik used, is they do not operate in a vacuum. And they determined what? Both doctors agree that this was a violent homicide, and that Evelyn Boswell died from some sort of asphyxiation. So, suffocation, I guess, is the easiest way to say it. So, if it was not for, say, the position of her body upside down in the trash can, that could have killed her. Well, say it wasn't that. Then maybe it was the blanket that was pulled up over. Remember that? How it was tightly pulled up over her face. That could have been what it was. Or it could have been upside down in the trash can. Could have also been the trash bag that she was placed inside of, where she was unable to breathe. Could have been the foil that was wrapped around her head. Could have been the trash can itself. If you remember, the doctor testified that her face was compressed up against the side of the trash can. And her body was in a reverse S curve to where her head was so far bent back into a reverse S because of how the defendant compressed her body down into the trash can. Forcefully compressed her body.
I think this is the face I was talking about.
Her head and neck were wrapped so tightly with foil that even when they removed the foil, you could still see the impression of the foil on her face. You could still see the trash can form still to her face. Quickly, I'm going to ask you to go to your verdict form page. And it's going to be probably at the very end of your packet. Page 50 is where it starts. So these verdict forms, I'm going to show you one example. Okay. So you'll see here, this is just for count one, and I'm just giving it as an example. We, the jury, find the defendant and mark the appropriate box. So if you go back in the jury room and you agree as a whole that Megan Boswell is guilty of first-degree murder, you do not need to consider anything below that. Those are what we call lesser included offenses, and we're required by law to put those on the verdict form for you to consider. But if you unanimously agree that Megan Boswell is guilty of first-degree murder, you can check that box and move on. You are not required to go through every single one of those if you believe that she is guilty of what she's charged with in that count. And if you go through these, you will see that each count of the indictment is similar. There are lesser included offenses for each one of these. Again, I will ask you that if you can unanimously agree, you do not need to go any further on that verdict form. The state has to prove several elements for each charge, and those are also in your packet. Count one is premeditated first-degree murder, that the defendant unlawfully killed the victim, that the defendant acted intentionally, and that the killing was premeditated. The next page defines premeditation for you as an act that was done after the exercise of reflection and judgment. It means that the intent to kill must have been formed prior to the act itself. So that means essentially when Megan Boswell wrapped Evelyn in the blanket, and you think, well, maybe she didn't have premeditation then. She could have formed premeditation in the time where she applied the foil. Or premeditation in the time that she put her in the
told
trash
y'all premeditation.
bag. Or premeditation in the time
Can
that she pushed the
be
next
at
trash bag
any
on top
time.
of somebody.
Told you.
Ladies and gentlemen, I submit to you, there is nothing about this case that is not premeditated. Count 2 and count 3 are what we call felony murder in the state of Tennessee. That's where we allege that a murder happened during a certain felony. And these felonies are aggravated child abuse and aggravated child neglect. Again, those go hand in hand with premeditated first-degree murder. We submit to you that not only did the defendant abuse the child, but that she neglected the child. And one of the perfect examples is how she left her in the trash can. That's neglect. Leaving her in the trash can, that's abuse. And it resulted in her death, which is felony murder. And we have to prove that the child is under the age of 8. There are many counts of false report. Page 29, I think, is where it starts. And it's counts, I believe, 7 through 17. The state must prove that the statement was made by the defendant, that it was made in response to a legitimate inquiry by law enforcement, and that it concerned a material fact about the incident within the officer's concern. And if you remember, the defendant herself admits more than once that what she told the police was not true. So I submit that the state has proven each of those counts. Count 19, abuse of a corpse, page 30. The state must prove that the defendant mistreated a corpse in a manner offensive to the sensibilities of an ordinary person, that she acted without legal privilege and acted knowingly. And I think that count speaks for itself, along with count 20, which is failure to report a death. A lot about this case really has been more about Megan Boswell than about this child, Evelyn. But Evelyn mattered. She deserved to grow up. She deserved that, but her mom took that away from her. And there's no evidence that anyone else was involved. I think you can see this was a pretty good investigation. It was very thorough, and the evidence continued to point in only one direction. The evidence only pointed at one person, Megan Boswell. She failed her daughter. She had the chance to keep her safe, to protect her, to give her to someone else if she couldn't handle her.
Judy,
You
anybody?
heard from the witnessing, there were people that she could have given Evelyn to that would have given her a beautiful life.
Believe whatever you want to believe in my
But
check.
instead, she violently murdered her daughter. She told story after story after story for 2.5 months. And maybe the worst part is that she just went on with her life as if Evelyn had never even existed. But Evelyn did exist. Evelyn is a real person. And Megan Boswell should not be able to go on as if Evelyn did not exist. There are things we will never know about what happened. None of us will ever know everything. I think it's fair to say that we do know that Evelyn was in the way. She was in the way of Megan Boswell living the life that she thought she deserved, that she wanted to live. So Megan removed her. It's as simple as that. So today, 5 years later, almost 5 years to the day that Evelyn was reported missing, we are going to ask that you hold Megan Boswell accountable for what she did for her child. I submit to you the state has proven every count and every element of every count beyond a reasonable doubt. And we are going to ask that you return a verdict of guilty.
Thank you for bringing that up. I
Thank you, General.
noticed that. Thank you.
So, you may close.
It's interesting.
Good afternoon. I appreciate your all's time. Appreciate you being here. Well, I know you may not be here by your own free will, but I still appreciate it. This is a hard case. There's a lot of emotion in this case, and Amber Massengill is very good at giving an emotional closing and wanting you to play on your emotions. Jury instructions will tell you that this case is not about your emotions. It's not about sympathy. It's not about anything else. It's about proof and what's in the evidence. That's what this case is about. This case is more about what Megan Boswell didn't do than what she did do. Now, I'll go back through the witnesses here with you in a minute, but the state seems to be putting forth a theory that you should convict her of first-degree murder because she didn't grieve appropriately. She had fun after her child died. Now, is it far-fetched to believe that the child died in the first part of December, like she says? No, that seems to be the point where you see Megan's personality start to change. But I would suggest to you that change occurs when the child dies. You start to hear various friends come in and they talk. I can name them for you. Let's talk about Casey Saltz. She worked at Megan's pediatrician. And she was also technically would have been Megan's foster sister, I guess. She was the daughter of Megan's foster mother. And she talked about Megan being a good mother. She acknowledged that. She witnessed that. Megan brought her to the doctor. You have an exhibit in the records. It's item 67. It came in through the pediatrician. Read that page. It demonstrates that Megan was a good mother to Evelyn. She took her to the doctor for well checks. She took her to the doctor when she was sick. She got medicine for her. She did what she should do. And then she misses that appointment in December. And that's when this starts. And I would submit to you, when all of this really starts, the child is dead. Now, we hear from other witnesses. We hear from Paul Miller. That is Ethan Perry's grandfather. He had no reason to believe that she wasn't a good mother. Seemed like she liked being a mom. Saw no signs of abuse or neglect. We heard from Audrey Gibbs. She'd been with Megan almost every day up until she moved to Knoxville in 2019. She describes Megan as a good mom. There were a few things. There was once where she had thought her diaper needed to be changed. Once where they neglected to buckle the car seat. But those are mistakes. That's not child neglect. That's not child abuse. Those are mistakes. Audrey talks about Megan coming to Knoxville at the end of December sometime, and by that point she's actually disassociated. She's not normal. She's saying "I love you" over and over again to her. So again, maybe she's not grieving right. Bailey Hawkins stayed at the Econo Lodge with Megan. Megan just went to sleep, despite Bailey thought they might do things. They might talk or whatever they might do. But she just went to sleep. Again, I would suggest to you she's disassociated. Bailey saw no signs of abuse, no signs of neglect. Mr. Horn questioned her. She described Evelyn as the one consistent love that Megan had. And Megan is a girl who comes from a world of fractured relationships. And Miss Massengill wants to downplay Megan's home life. Matt Price did. There's a video in there. He talks about it. He talks about, I mean no disrespect, but I know that Boswell family. I'm aware of them. I know how you come up. Your mom and daddy using drugs. I mean, you want to talk about home life? Watch the video with Agent Fraley. Her mom was let in there in stripes, a jail uniform. What kind of home life was that? And then we get to Caitlin Jones Carter, whom you can make what you want of her testimony. Her body language tells me she's no longer Megan's friend. However, she described, aside from the one day when she saw Evelyn as dirty, Megan had been a good mother. No signs of abuse, no signs of neglect. She said she saw Evelyn sometime in December. She tried to tie it to her school, but she really couldn't give us a specific date. So I think the best you can say is that it's sometime in December. Gail Kite. Let's talk about her. Megan's foster mom. She gets Megan when Megan comes into her foster care. Megan's 7 months pregnant. She's 17 years old. Gail describes her as looking like she's not pregnant, as being underweight. We know from the medical records and the testimony that come in from Dr. Smith, Megan suffered from intrauterine growth restriction at that time. We've heard that. So that's the shape she's in. But Gail talks about how she gets her in good shape. She has the baby. She's a loving mother. She takes care of the baby. Gail never saw abuse, never saw neglect, never had any doubts about Megan. Erica Stacy, and that's the mother of Megan's ex-boyfriend, and I think his name is, I can't remember his name honestly. That's the mother of his ex-boyfriend. She described Megan as a good
Oh my God, because she had so
Evelyn was
many. I
always
don't remember
clean.
her name, honey.
And I'll point something out to you. The state wants you to believe that Megan just meets Hunter Wood and throws this child away for him. She didn't do that for, I think it's Caleb Stacy. She didn't do that for Caleb. There were other boyfriends. Now there's talk about, a lot of talk about Ethan Perry thinking he was the father. Well, the proof you've actually seen is they go about as Ethan is the father. And there's been no proof that Megan knew that he wasn't the father at that point. I'm not trying to, I mean, it just happens that sometimes people may think one person's the father and they're not. But calling him out of anything or anything else. Like, it's not like this didn't start early on that she thought Ethan was the father. She obviously thought a lot of Ethan. She drove to Texas, took Evelyn to see him. Now, he did say one thing that kind of struck me a little odd. He acted as though she just showed up in Texas. I suspect, and he finally admitted on cross-examination, that he told her where he was in Texas. You just don't hop in the car and drive to Texas and say, I'll drive around El Paso until I see his car in the parking lot, pull in. That's not what happened. I think he kind of wanted you to think that, but that's not what happened. Let's talk about Randy Wood. Randy Wood is the father of Hunter Wood. The state called him. The state is the one who elicited the information about Hunter Wood being hospitalized. That's the first you hear of him being hospitalized. It's the state. Now, Ms. Massengill wants you to think I have some grand conspiracy theory. don't. I do have a statement from Megan Boswell when she talks to Agent Fraley about what happened in this case. She says, Hunter was there when Evelyn died. I wrapped her up and I swallowed her. I held her. She kept getting colder as the day went on. I didn't want her to get cold. Hunter took her and he got rid of her. Now, they want you to believe that that's just impossible. Why did Hunter not give his DNA? Ask yourself that. If you have nothing to hide, why wouldn't you just let them test your DNA against all the evidence they had? Turns out they couldn't have tested it, probably. But he didn't give them that chance because he had something to hide. Now, his dad said that he was schizophrenic. I asked him, is he schizophrenic and have hallucinations? He agreed with me on that. He also agreed with me when I asked him if he talked about using an aluminum foil or tin foil. And he says, yeah, he talks about some off-the-wall stuff. Now, ask yourself, who's more likely to wrap that child in tinfoil? The child's mother that has cared for the child, taken care of the child, or the boyfriend who's schizophrenic? And I'm not trying to vilify Hunter Wood. That's not been my intention throughout this trial. But Megan's statement is that one of them rolled over on the bed. And the young mother may think that. There could have been other causes. When we get to the causes, I guess we can go ahead and we can talk about Dr. Smith and Dr. Malushnik. Now, Dr. Smith asked her about several different things. She's the lady who actually performed the autopsy. And she formed an opinion of homicidal death based on the way the child was in the trash can. But she could not tell you a medical basis for the child's death, other than a diagnosis of exclusion. And a diagnosis of exclusion is simply, we don't know what else is wrong with her, so she must have smothered in this trash can. That's what they want, what she said, essentially. Now, I cross-examined her about a lot of things. I asked her about SIDS. And even though the subsequent doctor didn't agree with it, Dr. Malushnik, I didn't ask about something that didn't exist. Dr. Smith knew exactly what SIDS was. We talked about it. We talked about the ages, how we don't know what causes it. She answered questions about it. She said, ultimately, she could not rule that out in this case. Just like she could not say with any degree of certainty that the child was placed in the trash can alive and dead. She couldn't say that. She brought up that the child had a heart valve that leaked. She admitted under cross-examination that that could have been what killed the child. We talked about laryngeal, we talked about laryngeal convulsions. Could that have caused the death of the child? She admitted it could. Now, Ms. Massagill brought up tongue tie. I brought up tongue tie. I brought up GERD. I brought up an infection she had because all of those things can lead to the onset of SIDS. That's the research, and Dr. Smith agreed with that. Now, I want to tell you something about Dr. Smith and Dr. Malushnik. I think Dr. Smith she was the medical examiner in Johnson City when this happened. Dr. Malushnik is not her boss. She's not, it's not like she's somehow over her. Dr. Smith was the chief medical examiner at the Jenkins Autopsy Center, Forensic Center. Subsequently, for whatever reason, the state sent her report to Dr. Malushnik for another opinion. Dr. Malushnik only reviewed her report, and she finds that it's a good report. But then she wants to go further and find with some type of certainty that that child was placed in the trash can. And you saw an exchange between me and her in here yesterday. It went on for 4 or 5 questions. And I kept asking her, doctor, can you say any type of certainty? What can you say about this? Can you conclusively say that that child was dead when it was wrapped in the blanket, wrapped in tinfoil, and put in the trash can? She evaded that question. She wouldn't answer that question. She finally answered that question only after it was threatened she would be in contempt if she didn't directly answer the question. And her answer was, no, I can't say conclusively. And then she threw out kind of a parting shot at me as she left. And suggest to you the more accuracy of that parting shot, she said the child could have been murdered some other way. Should have been. The child could have died some other unknown way. That's what the truth would have been. She presupposed that this child was alive when it went in the trash can. The doctor who did the autopsy was very clear she could not conclude that. She said it couldn't be excluded, but it cannot be included. Dr. McLustick come in with a preconceived notion of that's what happened. Now, the state has to prove to you cause of death in this case. They have to prove that child was unlawfully killed. They have to prove this wasn't an accident. The proof from Dr. Smith leaves open a heart, it leaves open SIDS, laryngeal convulsion, it leaves open all of those things. We don't know what happened. It also left open a rollover, which is what Megan told Agent Fraley. And now, would Megan know for sure that that's what happened? Maybe not. You wake up and you find your baby dead in bed. Could you not come to the reasonable conclusion one of us must have rolled over on it? She's 17 years old. She's not sophisticated. She's had a hard life. She's scared that she's going to get in trouble. Hunter Wood's scared that he's going to get in trouble.
It's no
And that's
excuse
why.
for Megan to do that to her child.
That's why she does what she does. Hunter takes the baby to dispose of it. She knows about it. Is that right on her part? No.
Oh my God, he needs to stop.
Should she have called and reported? She absolutely should have. I told you that in my opening statement. Have they proved that she's a liar over and over? They have. Don't deny that. They haven't proved she's a murderer. You have more counts of false report than I can really count.
And besides that, if Hunter
there's
had
another
did that, she would have called 911. Bullshit.
Almost every time she's talking to law enforcement, you're considering a count of false report. With the exception of, you're not considering one for the time she talked to Agent Fraley. That's not before you.
Hey, Mama,
I'll submit to you what happened was the conversation with Agent Fraley on the 25th of February, almost 5 years ago. That was a breaking point.
evil.
That's a breaking point where she finally admits Evelyn is dead. She's able to admit to herself. You saw all these pictures she's sending back and forth before that. That's how she's grieving. Maybe she doesn't want to accept that the child is dead. Maybe as long as she keeps talking about it, talking to the media, talking to the police, and saying that Evelyn is somewhere else, she believes that. Maybe that's how she's getting by. You can't judge someone for how they grieve. You don't know what goes through their head. You don't know what they were raised with. I've never lost a child. I hope none of you ever have. But how am I to tell someone when they lose their child how to grieve? How am I to do that? Amber can tell you that. Oh, she shouldn't have went here. She shouldn't have did that. How does she know that? She's not in Megan's shoes. She's not out there living in that single wide trailer. That's not her life. She's not been raised by drug addict parents, a dad that beats on her mom constantly, and seen that growing up.
How does he know that?
She's not seen that. She can't put herself in her shoes. It's not fair to say she murdered her child because she didn't grieve right. I resent it. You should too. You should look to the evidence in this case. Do they prove a cause of death? That's the stopping point on the homicide counts. They can't do it. They brought 2 medical examiners in here who contradicted each other. The first one at least had read her medical records. The second one talks about how she is perfectly a healthy child. She ignored everything in her medical records. She didn't talk about them. It was obvious to me. Should have been obvious to you. She hadn't read them. She didn't care. It was her job to come here and convict Megan Boswell of murder. If you don't believe that, why would she leave here and say, well, she must have been murdered some other way? She was a biased witness, and she wasn't a credible witness.
Yeah, he's yelling at the jury, for God's sakes. It ain't even like he's yelling at the other side of the defeat or the state. He's yelling at the jury.
How can her one fingerprint be on a piece of tinfoil? You all see this roll?
That he's digging her
Maybe like this.
own grave.
Okay, my fingerprint's on this roll. I've taken this one. The next person who gets this is going to get a piece of tinfoil with my fingerprint. That's a possible way. What's another possible way? We've heard that the tinfoil had food and debris on it. So there's food and debris in the trash can. But maybe the tinfoil was already thrown away in the trash can. If it came off of a roll like that, whoever got it would have had to have reached in there and gotten several pieces. There were several pieces of tinfoil. I believe 4. There should have been fingerprints all over it. One fingerprint. One fingerprint. It doesn't prove she put that tinfoil on there. Now, what about DNA on the garbage can? I would just about guarantee you, each and every one of you, your DNA is on your garbage can in your kitchen.
Oh my God.
Your DNA is all over the house. Your finger, I said DNA, actually it's fingerprints. Your fingerprints are all over your house. It's the kind of thing we don't think about, but you touch something, you put your prints. I think
So
that's what you
I
should
wonder if
consider.
she'll give a little interview after
Probably Evelyn's
this.
handprint on the trash can. At some point, I think in the opening, I mentioned to you an unidentified palm print on the trash can. Well, I didn't know at the time it was a child's because it wasn't in the fingerprint analysis report. It's not unbelievable that it's the child's. Now, Ms. Maxingill made a statement, I was a little perplexed with it. The state wants you, or the defense wants you to believe that wearing gloves prevents putting fingerprints on something. You heard the fingerprint experts say that it can. I think we all know that from our common sense stuff. If you cover the fingerprint up, you're not going to leave it on something. Now, let's go back to the statement of Agent Fraley. February the 25th. She's talked to law enforcement over and over.
I hope you don't have a wedding
She
ring on
talks
that.
about how she breaks down. She breaks. It's the breaking point. She admits she's dead. And she's telling them the truth. How do you know she's telling them the truth? Because if she's still trying to lie to them, if she's still trying to confuse them, she wouldn't have said, I don't know where the baby is. It could be at Hunter's, it could be at Tommy's. Why would you say, if you're trying to lie to them, perpetuate this lie like Miss Masseyville tells you, that the baby could be at Tommy's? Why would you do that? Ask yourself that question. She's
Yeah, I
telling
don't know
you
why the judge
where the
don't
baby
want
is.
to tone his
Says, I
ass
think it could have been
down.
left one of these two places. Says, I want to find it. And you'll have that video. You can watch it as many times as you want to. I hope you will watch it again. You hear Agent Fraley talk about how he'll go to the DA. She's a scared young mother. He understands that. Now, I don't have to prove this case. I wish I could, but I can't. You can't prove a negative. What I can tell you is the state has not proven their case. They've not proven cause of death. They've not proven that the death was an unlawful killing as opposed to an accident, or some rolling over in the bed being an accident, or some kind of health-related issue. They haven't proved that. Let's talk about the gloves. I go around in circles sometimes, and I hope y'all are following me. I apologize for that. But let's talk about those gloves. Ms. Masseyville talks about the criminal tore the gloves up in the trash can. I think if you'll remember back and look to your notes, TBI put those gloves up for testing. I could be wrong, but I think that's the case. Now, what do those gloves tell us? Do they match up to anyone? No. But they do match up to an unknown male. There's not enough profile there to match it to someone specifically identify them, but it matches it up to an unknown male. That's why there's not multiple fingerprints on the tinfoil on the child. Those gloves that match some unknown male. We know it's male DNA. We know that. Finally, let me talk just a little bit about Hunter. There's a text thread, and it's in February. It's between Megan and Hunter. And it appears like Megan's telling Hunter the same story she's telling everyone else. But remember, Megan's told Agent Fraley that Hunter doesn't want his name brought into this. He doesn't want to be involved. He told her not to tell anybody anything about the child. At this point, Hunter, he throws out a name in that text. He talks about Agent Wilhoit. He's been involved with the police. He knows the police are looking at this. This is February the 22nd. Suggest to you that text thread is, look at those texts. They're self-serving. I'm just worried about the baby. I just want the baby returned safe. That's Hunter and Megan's way of covering Hunter's involvement in this. I'm not saying Hunter killed that child. I'm saying he did dispose of the child. That text thread, it's a convenient way if you think about it. If you're trying to
At this point, he just needs to leave Hunter's name out of it.
Start texting it. Say, oh no, I didn't do that. Look at my text. I texted her. She's told me this. It's a convenient thing for him. But he didn't give his DNA. We know that. His dad talks about he went crazy because he was called a baby killer. Maybe he went crazy because of his participation in disposing of that body. We don't know. Everybody seems to agree he has went crazy. You saw a document this morning. That's where he's being held out of court over in Virginia to be evaluated to see where he's competent for some crime he's committed. He's up at Marion right now to be evaluated. That's what we know. I hope I've answered your questions. I hope my argument has helped you somehow with this case. But what I would say to you, if you have questions, about any of the elements of these crimes, and your questions are not answered to your satisfaction, you have reasonable doubt. If you say, I don't know how that child died, that's reasonable doubt on this homicide. I don't think I have much more to say to you. I go to a Baptist church and I hate long sermons. I'm used to it. I think I've been up here for about a half an hour, but I think you.
Did he just? No, he just did not.
The right decision.
Absolutely, he just did not just say that about the church.
Thank you, Mr. Scott. General, you may close on behalf of the state.
Thank you, Judge. Ladies and gentlemen, much like Megan Boswell, Mr. Scott seems to have some very convenient explanations for what happened in this case. Lots of things that happened in this case. All of the evidence in this case that points to his client, he's got some sort of explanation for it. But the problem is, in order to buy into this, in order to believe it, you have to believe Megan Boswell. You have to believe that when she spoke to Agent Fraley on the 25th, that she was somehow, for the first and only time in this courtroom, speaking the truth. But I think each of you, as you sit here, know that's not possible. That's not possible. Megan Boswell is one of those people. You used to hear the expression, the truth ain't in them. The truth's not in Megan Boswell. She doesn't know how to tell the truth. Everything that she tells to every person in her life is for some reason. And that reason is because Megan's trying to get something out of it. She is a master manipulator. Even at 17 years old, you sit there and watch those videos. She's trying to play everybody. She's trying to play the law enforcement officers who are interviewing her. She's playing her friends, every person in her life who walked through that gate and sat up on that witness chair was in some way manipulated by Megan Boswell. Some way. Whether it was about Evelyn, whether it was about how she was going to pay for a babysitter, whether you're the father of my child, whether you're a great-grandfather, whether your wife who's dying of cancer is babysitting the kid. I mean, she knows no bounds. There is no person that she will not manipulate and tell untruths about and to. No one. But Mr. Scott comes in here today and says, yeah, hey, come on, ladies and gentlemen. You know, the 25th, you could, that was the point, which she decided, hey, I'm going to be. No, no, it wasn't. And we know it's not. It was just another story. She was telling law enforcement to lead them some other way. That's all it was. And if you remember, Agent Gratz testified. General Massengill was asking him the question, when did this first thing about accidents and rollovers, when did that come up? Well, it came up when the police and law enforcement finally said, we got nothing going on here. We got to give her an out. We got to give her something so we can try to find this kid. They're the ones who suggested it. And then very conveniently, the next day, she comes in and guess what? Oh, yeah, I forgot. Yeah, that's right. I'm sorry. I'm sorry I've been lying to you all for days and days and days now. But now I'm going to tell you the truth. But that's not what happened. That's not what happened. I submit to you, the only time that Megan Boswell may have told the truth about some small portion, if you remember during one of the interviews, Lieutenant Price, who had been very patient with her up until that point in time, finally said, come on, something happened on December 21st. And she stopped him and corrected him. Remember? She said, no, something happened before December 21st. Yeah, something did. She murdered her child. That's what happened before December 21st.
Ladies and gentlemen, before I speak further about the physical evidence that ties and shows that Miss Boswell is the one who is guilty in this case and who needs to be held accountable, I want to take you back to jury selection. Last week when you all were first up here and up there, and I asked you if all of you had brought your common sense with you. And if you, all of you, as you listen to the evidence in the case, would use your common sense. And everyone agreed that you would. And so I want to remind you of that. And it reminds you to apply that to the evidence that you've heard, the testimony that you've heard in this case. Because the defense wants to say that perhaps, again, speculating, it's a possibility that Evelyn just died one day in early December. And then all of a sudden, Megan engages in this just pattern of just totally bizarre behavior that involves wrapping her child in a blanket, tightly pressing her head in aluminum foil and stuffing her in a trash can, and then engaging in this just convoluted tale to anybody who wants to inquire about what's going on with Evelyn. But it's a remarkable coincidence, isn't it, that all this occurs at the same time that she starts working at the chicken shack. And then she meets Hunter Wood. You know, that Hunter Wood, the one who lives out on the lake in the big house. And remember, this is where Megan's living before December. These are the conditions Megan's subjecting her child to before December. Then she meets Hunter Wood. Big house out by the lake. Dad owns a business that I'm working at. There's other things she's telling investigators as time goes on. Needed a break. Watching 3 kids. Remember, her mom had the 2 other young siblings. Needed a break. Was tired. Wanted Ethan Perry to step up. I've been raising this kid for a whole year by myself. Probably a little bit of truth in there. A little bit of truth. But it's a remarkable coincidence. This kid, Evelyn, natural causes, just dies right at the same time. Apply your common sense in asking yourselves why. Why would Megan Boswell then start on December the 7th? She tells Bailey Hawkins, hey, it's just me. Ethan's grandma has Evelyn right now. December 7th. Remember, she starts Chicken Shack the 2nd, 7th, 5 days. 5 days later. Why does she start telling all these things that are obviously not true? I'm in a custody battle with Ethan. I don't have her. Evelyn's sick. She's got the flu. I can't bring her. Can't bring her up there to get the Christmas gifts. Let you see her. Why does she do that? Why does a mom who, by everybody's testimony, everybody's, her friend, Bailey Hawkins, yeah, she's a good kid. We didn't have any concerns. Healthy, meeting milestones, an advanced child. Why does a mom who dotes over her kid, who won't even let anybody babysit, she's so protective of this child? Remember Erica Stacy? I mean, heaven's sakes. I mean, that's an ex-boyfriend's mom who is willing to babysit the kid so that her son can go on dates with her. She won't let her do it. She won't let her do it. She will not let her babysit. That's how protective she is of this child. So why? Why? Apply your common sense. She won't do it because she can't face the truth about what she's done. She can't face that truth. She can't look at that picture. And I'm not going to put it back up there for you. She can't face what she's done to that child. discarding her like a piece of garbage. That's what she did. She can't face that truth. So she engages in just spinning all these stories to everybody. Everybody that comes with a story, she's deflecting that out because she doesn't want to face that. It is almost unbelievable to me that the defense is still arguing that Hunter Wood had some involvement in this case. I mean, truly unbelievable to me that they're making that argument. That has no credibility, number one. And two, no proof whatsoever. Not a single shred of evidence has been presented in this courtroom that ties Hunter Wood to anything dealing with the death of Evelyn Boswell. Not one thing. It's all just rank speculation. Oh, well, because he's in a mental hospital, therefore he must have done something. Right? No. How many people walked up there, took that witness stand and said, oh, yeah, I remember when I saw Hunter and Evelyn and Megan together. I remember when I saw that. None. Nobody said that. How many people said, oh, yeah, I remember when I saw Hunter holding Evelyn at the chicken? No. Again, nobody said that. No evidence, nothing from that witness stand ever put Hunter with Evelyn. She evidently wants you to believe, again, and I'll put this picture back up there. She wants you to believe that Hunter, and remember her when she's talking to Agent Fraley, that Hunter went over to her place. That's her place. Stayed the night with her and rolled over on the child. He's got a place over, nice place over on the lake, remember. But that's what she wants you to believe. When her breaking point, when she's finally telling the truth. Apply your common sense to that. What else possibly ties Hunter to this case? To Evelyn's body being disposed. Well, maybe it's the playhouse over on Tommy's property. No. Again, we know Evelyn is probably gone 5 days after she first met Hunter from working at the chicken shack. But Megan Boswell wants you to believe that he's been able to go onto her property and stick a body in a trash can in a playhouse that was built for Megan Boswell. Mr. Scott asked you, and I wrote it down. He asked you who was more likely to have left a print on the foil. Well, I'll tell you who's more likely to have left a print on the foil. The person whose print was found on the foil. Megan Boswell. He stands up here, and again, we've got explanations for everything. Well, maybe it was possible she tore a sheet off earlier, and in doing that, she grabbed the foil and left a print. Well, there's no Hunter Wood prints on any of the foil. The bag that's stuffed on top of the body where Evelyn's found. Multiple prints on that. None of them belong to Hunter. They all belong to Megan Boswell. He wants to say, and again, it's still beyond my comprehension that we're talking about Hunter Wood here. You know, why wouldn't Hunter give a DNA sample? I don't know. Perhaps because Hunter is being mucked up in Megan's world here. My gosh. Here I am dating this girl, and all of a sudden I got TBI agents asking me about a child that's missing and no explanation for it. Maybe that's why. And again, in this particular case, you heard from Agent Gray. What does it matter? There's nothing that was tested. All those things she testified to yesterday, all of them, all those things I handed up to her, she analyzed. Not one piece of them had any identifiable DNA on it that could have been tied back to Hunter. None. Everything was Megan's or Evelyn's or limited profiles. As I remember, I asked her if I gave everybody in the world's DNA to her, she wouldn't have been able to match any DNA to Hunter would. Nothing. Nothing. Everything connected to that body in the trash can comes back to Megan Boswell. And then, let's not forget, in the middle, while all this is going on, February 22nd, Megan's child's missing. They questioned Hunter. And they had this conversation. And Mr. Scott wants you to believe that this is some kind of contrived thing between Megan and Hunter. But what evidence did you hear that there was any sort of contrived conversations going on here? Nothing. Again, nothing. In order to believe that, you've got to believe one person, Megan Boswell. And we know you can't believe her. No. Hunter says, yeah, but where's the baby? I just want the baby to be found safely. What's her response? If she was truly trying to cover this up, a little bit better response would probably be heard. She says, Dad won't let me go anywhere because of the situation. Hunter, I can't disclose stuff to you on here about what TBI is doing. His concern, please assure me the baby will be found and brought home safely. That's not a conversation with someone that you have that has disposed of a body, that has helped get rid of your dead child. That's not a conversation. Hunter Wood is not at play here, ladies and gentlemen. Not at all. Not at all. Defense has also talked to you about these things that medical conditions that they questioned the medical examiners about yesterday. Possible things that might have caused Evelyn to just suddenly die of natural causes. A perfectly healthy child. Again, he's asking you to speculate about possibilities. But we don't decide this case on possibilities. And if you think about it, ladies and gentlemen, you didn't hear from just two doctors about Evelyn's condition, about what kind of a child she was. You heard from three doctors. Her pediatrician testified in this case too. And what did she tell you? Evelyn was a healthy child, advanced, had met all of her milestones. Any concerns about her health? No, her concern was that on December the 5th, she doesn't show up for her year checkup appointment. She's a no-show. That's her concern, not Evelyn's got tongue-tied. I'm concerned maybe she's going to die from SIDS. Not, oh, she's got some sort of reflux going on. I'm afraid she might be at risk to just suddenly die one day. That's not her concern. And remember, and Mr. Scott didn't talk about this because you don't want to talk about it. I asked Dr. Malushnik yesterday about statistics. This wasn't just her opinion. These are statistics kept by the Department of Health in Tennessee about the number of kids over 1 year of age who die in rollover deaths. Entire state of Tennessee last year, none. Entire state of Tennessee last 10 years, none. But yet they want you to believe that's a possibility in this case. She's the first one, ladies and gentlemen, evidently, the first one. No, it's not a possibility. You decide this case on the evidence that you've heard, and the testimony you've heard from that witness stand. And the testimony you heard from 2 different medical examiners said this child died from asphyxiation. That's what they told you. Both of them told you that. He said they had contrary opinions. They didn't have contrary opinions. One of them had a little stronger opinion, but they both had the same opinion. They both told you the cause of death was the same thing, asphyxia. And all the evidence in this case points to one person alone as being the person who caused that asphyxiation. And that is Megan Boswell. This wasn't an accident, ladies and gentlemen. It wasn't an accident at all. You've got lots of evidence of premeditation sitting over there in that box. This isn't a little piece of tin foil. This isn't foil like you stick around a baked potato and stick it in the oven. You saw it. You saw the photographs, and the foil's in there. Pull it out. It's a big old piece of foil. Mr. Scott wants to suggest maybe it was sitting down in the trash can. Somebody pulled it out. Nobody's using that much foil. Use your common sense. And remember the testimony from Dr. Malusnik yesterday about how that foil was applied. That blanket so tight when they're taking it off, the impressions left on that child's face. The foil, how painstakingly slow they had to pull it off because it was tightly compressed around the child's head. I submit to you, that's premeditation, ladies and gentlemen. That's intent. That's not an accident. Part of this case, ladies and gentlemen, that as Mr. Scott said, is really, it's sad. It really is. It's a tragedy. You think about all those people that you heard testify, how easily all of this could have been avoided. All these people, Bailey Hawkins, Audrey Gibbs, Casey Saltz, Gail Kite, Paul Miller, Erica Stacy. Any one of those people would have taken that child. All this could have been avoided. But Megan Boswell only cares about one person, and that's Megan Boswell. She started a facade back first week of December after she killed her child. She created this world, this web, you've heard it called. That's a pretty good description of it. It's a web. It traps and ensnares everybody that she comes into contact with. She started this facade back then, and it's continued and continued and continued. And she brought it in here to this courtroom in front of you. And she's trying to get you all to believe the rollover, believe the accident, believe my child died of natural causes, and that I just flipped out and engaged in this totally bizarre behavior. But in order to do that, you have to ignore the evidence in this case. You have to ignore the forensics that place her and her alone as the perpetrator of this crime. This case is the very opposite of an accident. It's an intentional and knowing murder of a child. Megan Boswell got rid of Evelyn so that Megan could do Megan. She enjoyed it. You've seen the pictures General Massengill showed you. Hanging out on Blowing Rock, going to the aquarium.
She let
Super Bowl
dog.
party. Megan Boswell sits here in this courtroom today as guilty as she was back in that first week in December. As guilty as she was on February the 18th, when she first came in there, Detective Perez, James Lewis interviewed. She acted all surprised.
I hope so always.
What are y'all gonna do? You gonna find my child for? What do you do when a child goes missing? Remember those expressions, those questions she threw out there? She sits here in this courtroom today as guilty as she was back then because she never learned the one lesson that we all know, which is that you're responsible for your actions and your choices in life. And she sits here because she refused to learn that lesson. You've heard her interviews. She takes responsibility for nothing. But today is the day that you get to hold her responsible for those actions, for her poor choices and decisions, for her decision to get rid of Evelyn,
Hold her feet to the fire.
to dispose of her like a piece of garbage. That's what she did, ladies and gentlemen. She disposed of her child like a piece of garbage. But her poor choices and decisions have a price, and they have a consequence. The state has proven to you over the course of the last week, Megan Boswell is guilty. First-degree murder, false report, tampering with evidence, and a failing to report that death to authorities. We ask today that you hold her responsible for those poor decisions by finding her guilty as charged.
Thank you, John. Thank you, the attorneys.
Where's her glasses at? She don't need them no more all of a sudden.
Mr. Hyatt, Mr. Selner, Mr. Arnett, you're the three alternates. If you will go with the officer. Just leave them in the seat. That'd be fine. And your notes as well. We'll just take care of them. The rest, what do you mean? Yeah, I'm going to finish the charge. All right. Now, back on page 49. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have reached a verdict, you will return with it to this courtroom, and your foreperson will deliver the verdict form to the court. Take with you the presentment, the exhibits, the verdict forms, the court's written instructions, and you may retire and consider your verdict as soon as the officer comes back to get you. name of the officer.
Everyone stand, please.
3:05 p.m.
Take the ones that you have.
Right. Leave the others.
Take one each of you, but don't worry about the ones that belong to you. You may be seated. Thank you.
All right. We'll be in recess, waiting verdict of the jury.
Woo, okay, y'all. We're going to be waiting for the verdict. We're on verdict watch. It is, let's see. So it's 2:00 now. It's 3:00 their time. Actually, 2:07, 3:07. Starting live verdict watch. Hold on. All right, let's see. Hold on a minute. See if I can do this. I was just going to see if I could do it. If I could do this, I don't know. Oh yeah, I pinned it. Okay, I pinned it. I learned to pin. I've never learned to pin before. Yesterday, and I still remembered how to do it. Okay, so let's live verdict watch. So we're on live verdict watch, y'all. What y'all think? How long will it be? You think it'll be fast? Who thinks it'll be 4 hours or less? Just asking. Whoop, 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 whoop. Yeah, that's what I said, didn't I? Oh, I said too. Good God. Come on, Smiley, get with the program. Unpin. Lord, unpin. Forget that. Remove. You're right. I am in that central time. Okay. I was just joking. I was just trying to see who was watching. Who was awake? Who was awake? All right. 3:07 and 2:07 Central Standard Time on jury watch, on verdict watch. Y'all know what I mean. You know what I mean? I just want to see when it starts. I just want to be able to know when, because if it rolls on over, just so we know. Now, what happens if it comes on? Yeah, but it's 3:10. It's 2:11 here now. Look, we done wasted 3 minutes, okay? It started at 2:07, 3:07, okay? Okay? I said, the judge said, Smiley said 07 is what her clock said. Yeah, Eastern Standard Time, but 2:07 Central Standard Time. I got to keep Central Standard Time in my brain, okay? We know they're on Eastern Standard Time. Okay? Okay? Oh my God. Eastern Standard Time. Look, we on Smiley's time. That's all that matters is we're on Smiley's time. We on verdict watch. That's all that matters. I just want to know how to count 1, 2, 3, 4, 5, 6, 7, 8, 9 hours. Let's hope it's not that long. But what happens is, I have a question. What happens if it's in the middle of the night and they come back and say, we got a verdict? They give you time to get up and get your drawers on. That's what all the others do, at least on TV. So is somebody going to call and wake me up? Because y'all know Smiley. Smiley be sleeping. This old lady be falling asleep. Honey. I'm just wondering. I want to be sure to get this one right. Millie's like, of course. Oh. Yes, ma'am. Y'all blow my phone up. Hopefully, no, seriously, hopefully they will. Hopefully they will come back today. I don't know. So no, really, it's 3:13 there. So they got out of court early. 3, 4, 5, 6, 7, 8. If they, my neighbor is popping fireworks. They're pissing me off. You can, Marley. Go ahead and email me. All right, they're going to play you music. I'll be right back. I got to go to the restroom and let my dogs out. I'm stuck. You heard the fireworks? I told you. What the heck? It's not the 4th of July. Okay. So, yeah, I don't know. What do y'all think? So, do y'all think it will be a long wait or no? Oh, yeah, they get on my nerves here with these damn fireworks. Oh, wait a minute. Oh, I'm on the wrong thing here. Let's go see what everybody's saying. I want to see if hold on a minute. I want to see if Mr. Scott's come out and told anything to the news yet. Hold on. Nothing recent. We'll see. I think, though, that the state picked up a little bit better right there. I can't believe that the judge read those 81 pages so fast, though. Good God. He didn't take a breath. That's when you think it'll be around lunchtime tomorrow? So, okay. So, how is it if it's usually fast, it's not good? Is that the way it works? And if it takes longer, it's usually good for the state? Is that the way it usually works? I can't remember. Let's see. Okay, this is just a guess. This is just guessing. The longer a jury deliberates, the more likely that they are carefully considering the evidence and they have a more divided opinion on the case, potentially leading to a more thoughtful verdict, but not necessarily indicating a specific outcome like guilty or not guilty. It can depend heavily on the complexity of the case and the juror's individual perspective. When a case involves, okay, let's see. No, that's not always true. Okay. Some of you are saying it's not always true. Well, I can't remember, but yeah, I hope it's today too. You had to play at 2.0 speed. Yeah, I've seen it both ways too, but I just remember I thought the longer it took, the better. Okay, so let's see what it says about a potential for a hung jury. In some cases, lengthy deliberations might indicate a high chance of a hung jury because that means they can't usually agree. It's saying a large amount of evidence presented during the trial can increase deliberation times. It depends on juror personalities. It can impact how long it lasts. Did it say 8 men and 4 women is what I want to remember is what it said? If that's the case, I don't know. The judge cannot force a verdict, but if deliberations, it says, becomes too long, the judge may intervene and encourage the jury to reach a decision, but they cannot force a verdict. Hey, Annabella. It says there's no set time limit on how long a jury can deliberate in a single day overall. The judge has the authority to manage the deliberation process and may intervene if the jury appears to be deadlocked or taking an unreasonable amount of time. Sequestered juries, in some cases where the jury is sequestered, they may deliberate for an extended periods without going home until they reach a verdict. Okay, somebody was asking this yesterday. No, you cannot refuse to serve on a jury. I know. I'm a little bit worried, but I think the prosecution did better doing the closing arguments than they did throughout the whole entire trial, in my opinion. Yeah, they showed out at the end. I need to go get me a phone and turn some phone lines on when they do have when they do the verdict. When they read the verdict, I'm sure a lot of people have a lot of stuff to say. Yeah, chat. What do y'all think is going to happen? Yeah, Butterfly Kisses said, I can convict her just on closing arguments. Annabella, do you want to come up here? Come on. Hold on. Come up here, Annabella. Come on, Annabella. Let's go. Let's go. Let's go, Flo. Hello, honey.
Hi,
Hey, what you doing?
girl. I've been up in here with you.
I know. I see that. How you doing?
I'm good. It's my day off.
Oh, you look wonderful.
Oh, thank you. It's cold here today. It's raining and cold.
Oh,
Yeah.
it looks
But
like
I'm nervous, Smiley. I'm really nervous. But they really did show up and show out at the end.
mm-hmm.
And I'm hoping that the jury gets it right.
I do too. I gotta trust in them though. They showed out at the end. They brought it at the end.
Yeah, they did. But what I will say is this, and I told you this earlier. She's not judged here.
Right.
She will be judged by our God Almighty.
Absolutely.
And justice will be served. But like I said earlier in chat, they came up with Evelyn's law. So she will never be forgotten, no matter how hard her mama tried to discard her.
Right.
Evelyn will save so many babies' lives,
Yeah.
and she will forever be Tennessee law. Or is it nation? Is it nation? Is it nation or is it just Tennessee? But it's Evelyn's law. So that baby will forever and always have a voice.
Yes. Absolutely. And she really thought she was going to get away with it.
Mm-hmm.
I don't know how she thought she was going to continue to get away with it, but
Yeah. That wild goose chase that, she sent everyone on, she was buying time and she was trying to, mama did it, mama's boyfriend did it, baby daddy did it, boyfriend did it, all the peoples did it. She she underestimated law enforcement,
Yeah.
She was very arrogant thinking she could get away with something so heinous.
Oh, yeah. And then wanted to pretend like she was pregnant again. And, girl.
Scandalous as hell.
Yeah.
Yeah. She was she was pregnant and they having a whole oh my God, I never will forget his mama. His mama didn't even want to talk about it. She was embarrassed and she was concerned for her son. And his name is being brought up today.
Yeah. Yeah. Even still in closing.
Yes. How embarrassing. And that guy will forever be known as Megan Boswell's boyfriend at the time.
Yeah. Ruined their business, ruined, everything. And lots of people's lives. She just thought she was going to get into money, live, high on the hog. I don't think he even, was serious about her. And, puts me to mind to Susan Smith, Casey Anthony. They just wanted to, the men didn't want the babies. So, hey, we'll just get rid of the babies. We'll just throw them away. They're garbage. Bye. Gone. Just like,
yeah. Oh, yeah.
Yeah.
Absolutely. They were in the way.
In the way. Yeah. Yeah. So why not?
It's so messed up.
I know.
I can't imagine the whole idea. Look, I'm a mother of 2 boys. I used to cry whenever they would cry at the doctor's office.
Yeah.
If they were getting their shots, I was crying with them. Could you imagine the heartless person Megan is whenever she shoved her whole baby into a garbage can?
Yeah. Yeah.
That's not a mother. She should never see the light of day.
No.
She should never be around any children, ever.
That's the only thing I'm afraid of. If she gets out, the whole world's going to be unsafe.
Yeah, absolutely.
To be honest. And the only thing I'm worried about is if she gets on lesser charges, they're going to give her time served. That's my only fear.
And she's been locked up 5 years.
Yeah. Yeah. But surely not. We just got to put our trust in, we got to put our faith in
the justice system.
And these jurors and just pray that they got common sense.
Now, I have been working for the past several days, so I didn't get to see everything. Did they ever show pictures of the crime scene?
Yeah. Yeah.
Did they show anything else?
They showed everything. They showed, they pulled the baby, of course we didn't get to see that. I got pictures of that, but they showed the baby being pulled out of the trash can. They showed all the foil being taken off, the baby being unwrapped. So, it's stuff that the jurors are not going to be able to unsee, and it had her fingerprints on the trash can. Her DNA was on the gum. Her DNA was on the bags.
The gloves.
Nobody else. There was nobody else's. Everybody was ruled out. Hunter was ruled out. Her mom was, everybody else was ruled out. TBI said that, there's nobody else. So whatever he was trying to do, Mr. Scott, even up until the very last breath on his, trying to defend her. He just is not, he just looked bad. He's the one that looked bad there on the end, in my opinion. I get what he was trying to do when he was trying to defend her. That's his job. But his arguments was bad. He was good during the trial, but his closing arguments was bad. I'm surprised the judge didn't put him in contempt.
Oh. Now, what did he say about the church at the end?
Something about I'd have to go back and re-listen to it, but he was talking about the Baptist church and how he had to go back to the Baptist, or how he had to be at the Baptist church and preach or something like that, wasn't it, y'all?
Oh my word.
Whatever.
I heard him say something about I've been up here half an hour, and he made mention to preaching and something to do with preaching. And I was like, what did he just say? Because I missed it.
And he was talking about the Baptist church and looking at his watch, and yeah. I know he just didn't go there, but he sure did. Yeah. And then he lied. He said he said, told Ansley Daniels that the father, he knew who it was, and the father, he kind of teasing, and then he's like, but it's going to come out in court, which it never did, which I don't blame that guy if he called up there and said they better not tell his name. He already asked for a mistrial. He's asked for an acquittal. He's did something every single day, shady to me, but
yeah. Well, I mean, we have to look at it like this. He is giving his 100% effort in defending this monstrous person.
yeah.
So, I mean, it doesn't, in his logic, it's not that he believes she's innocent or guilty. It's just to prove her to be, I think he's trying to prove reasonable doubt.
Yeah. Which that is his job.
Yeah, he's doing his job, and he's done a good job so far. But I'm telling you, girl, they showed out at the end, especially that woman. I was like, oh my.
Yeah. So she's been terrible the whole time, but she really did show up at the end, I think.
I agree.
Yeah. I really liked her at the end better than I liked her all week. And I just hope it works, but I don't know. I am a little bit worried. I'm not going to lie. If
Me too. I followed this case from the jump, and I'm talking about glued to the TV, glued to Facebook. At that time, I was on Facebook. That's how long ago it was. I mean, I could not rest until this baby was found. And I always knew that mother was sketchy. I knew Megan was sketchy.
Yeah.
But she literally had me believing that someone did kidnap her. Like, like wouldn't give her back or whatever, because she made the comment. She was like, well, I'm afraid because they might do something to her. And I was just like, I don't give a dang.
Yeah.
If that's my baby, I'm going to war for my child. I will bring the National Guard, whoever I got to bring. We get my baby back.
Yeah. I know in the beginning, again, I wasn't on YouTube, but I saw it on TV and stuff. And when they started saying, like when they were looking for her mother, and I was hearing all that, and I was thinking it was a good possibility that her mom had her. And like, oh my God, and I thought maybe she did, or she took her, and then her and her boyfriend, God only know what. But then I was like, this is the craziest mess. And then especially when I come on YouTube for Summer Wells and started hearing this mess, I'm like, Lord, that girl, she's got some kind of imagination right there.
Mm-hmm.
But I never a lot of this stuff I learned during the court stuff because I was following in summer, so I didn't really, I heard bits and pieces. Of course, I followed stuff to stay up with it, but I'm like, oh my God, what I heard in court, I heard with a lot of y'all. Hey, Denise and everybody coming in.
Yeah, I agree with fun to ski. We do give them the benefit of the doubt, but then we start to listen carefully, and then it doesn't make sense. It really, really, that's really a true statement. I mean, at first you want to believe the mother, just like you said, Susan Smith. You
Yeah.
want to believe them. You can't imagine what they're going through. But I'm going to tell you something about Megan. I don't know if I saw her shed a tear.
Yeah. Yeah. And I think it was yesterday. Oh my God. Because I thought, well, the day before, she had her hands over her face and then she put them down. She was like, you could see her crying a little bit. And then, or no, she wasn't crying. I'm sorry. She wasn't even crying a little bit. And I got real upset over that because that's when they brought the baby out and unwrapped the baby and everything. And I'm like, oh my God, who would not, even if they didn't do it, would not be upset over that? So then,
Yeah, I couldn't imagine seeing that sight as a mother of one of my boys. I just can't fathom that. And again, you can't unsee those images. I hope they haunt her. I
Yeah.
hope they haunt her every single day. And like I said, I hope she never sees the light of day. I really do. I hope the jury gets this right. There is so much against her as far as the DNA goes, but he's making a lot of sense. He's trying to confuse them. He's trying to give them reason for reasonable doubt. I get it. I'm so glad I don't have their job because I wouldn't be able to keep from saying stuff in court. I would have been just, I would have been a mess.
Yeah, me too. And then yesterday, they spin over on her, and then she had her hands over her face, and I thought, okay, I'm gonna watch and see what she's doing today. And I'll be dang, I was fixing to move my camera because I was taking pictures of her.
Yeah.
And I thought, oh my God. She moved her one hand, like her thumb and her finger back or something, so she could spy on the jury over there and peeped out of her hand, her fingers, to see if the jury was looking at her. I am like,
Oh my God.
Yes, I got that on film too. I'm like, are you kidding me? This crazy woman right here. And when I say crazy like that, y'all, she ain't crazy. No, I don't mean crazy like she ain't got no sense. She was doing that because she was trying to see if they were looking at her because she wanted them to think she had her hands on her face crying. She was not shedding a tear. See, her attorney said something to her and she had put her hands on her face. Maybe they were telling her she needed a little bit of motion or something. And oh my God, God knew not to give me them kind of jobs.
I know that's right, girl. I would have jerked her by the hair of her head across that table.
Mm-hmm.
And thank God that Megan had a grandfather that took it upon himself to report these things.
Yes. Yes. I am so glad that Tommy reported this. I'm so glad.
Yeah, I mean, because there's no telling how long this would have gone on. It's a travesty. I mean, it's despicable. It's evil. There's absolutely no sense in it. I mean, it was senseless. If she did not want this child, there was a whole slew of people in that family that would have gladly taken her.
Oh, there was so many people. This baby was so precious.
Absolutely.
So many people gave her so many chances. She burnt so many bridges. Even one, was it Caleb? I don't know if that was his name or not. The one lady that testified, it's hard. You have boys, but it's hard to even care for the girls because they're so I say trifling. These girls out there are trifling, but that one lady, I felt so sorry for her because she really cared for Megan and she cared for Evelyn and she tried her very best when she was with her son that already had a family made, with Evelyn, and she loved them both and gave them every benefit of the doubt. And when Evelyn went missing, I can't remember her name, but when the black-headed lady, and when Evelyn went missing, she tried to help Megan find her and when she found out it was probably a ruse, tried to get Evelyn to talking and everything. But she really cared for Evelyn. You could tell it really tore her up, and she was still tore up here 5 years later.
Yeah, it never goes away. Your love for someone never ever goes away ever.
No.
And Judy C, she says, I think she liked the attention while being interviewed by the police. I could not agree more.
Listen, y'all think I'm kidding. When that cop gave her that phone, I literally think that girl thought that cop was going to call her. I swear to God, I do. I am not lying. I don't think that girl thought one iota about her being traced. I really think she had the hots for that cop, and that's why she went back in the police. Who in their right mind, one, is going to take a phone from a cop? Two, and even Candace with Ernie threw the damn phone and the freaking had sense enough to know she was being traced. Who in their right mind then would go back in the police station and just hang out? She could have went with her friends or anywhere. This girl was nothing but man crazy. She didn't care what man it was. It could have been a cop. It could have been Bojangles. She didn't care.
Nope.
This girl was nuts.
Absolutely. 100%.
Man crazy. Crazy.
She was like a dog in heat.
Yep.
Anybody give her the least bit of attention, she was wrapped.
That's all she wanted.
Mm-hmm. Now, I understand that she, from what I've learned, she had a rough upbringing. She had some things going on in her early childhood life or whatever. I get that. But with that being said, you'd want the best for your child, knowing where you come from. You would never want that type of lifestyle for your child.
Yeah.
And you would protect your child. You'd never, ever harm your child, much less be their demise.
Yeah.
You
always want better, and you always want to do better, no matter what your childhood was. That's no excuse. And see, that pissed me off today. He was trying to bring that up.
Yeah.
There's no reason to put your child in a trash can and kill your child or whatever. That Erica Stacy, was that her name? Caleb's mama. Thank you for that. 1-800 something. What I was getting at a while ago, that lady, she could have even gave Evelyn to her. I believe she would have took Evelyn in a heartbeat. I believe the foster mother. Hell, I even believe her friends that come testified would have cared enough, as young as they were, to take Evelyn. Anybody in this world would have took that baby and been better, in my opinion.
I agree. I agree. I couldn't agree more. Yeah, totally.
There's no excuse. And he keeps getting her age wrong. She was 18 years old, and it wouldn't matter if she was 18, 17, 16. I just turned 16 when I had my first one. I have no embarrassment, no nothing about it,
Yeah.
Nothing. And it just comes natural to me. Some people, it just comes natural. Some people, it don't. You have to have help. You have to have help sometimes. But you know what? I wouldn't do anything different. Nothing different.
I think it got to the point where Evelyn was getting in the way. Like, she couldn't go out and do things like all the other kids. And she was just in the way. And she thought, if I can get rid of this situation here, I can have the life I've always wanted, and I can have another baby later.
Yeah. And then I think what she was doing is saying she was pregnant because she was trying to entrap Hunter, which is what, even way back when, 30 years ago, which is what so many people did to try to entrap somebody, and she was counting on that. And then when she wasn't pregnant, she was probably trying to get with every Tom, Dick, and Harry to get pregnant and still entrap him. That's just my opinion. I don't know that to be true, but all that is my opinion from what I've gathered here in 7 days.
Yeah.
Don't take a rocket scientist to see that.
Mm-mm. Yeah.
But I hate it. I just hope they make the right decision.
Girl, I do too. I hope that we get a verdict this evening. I hope that it doesn't last days. Sometimes it has been known to go a couple, there's been times where it's gone a couple days.
Yeah.
Sometimes the judge has to intervene and be like, we're going to have to do something. We need something. And sometimes the jury will come back and ask questions, and then they'll go back into the,
I've
they'll go
seen
back right again.
I've seen it where they hadn't been sure about something, or they've come back and asked questions, or they've just had a hard time, or it's been real easy for them. It's been simple, it's been cut and dry, and it's been, hey, this is XYZ, and it scared the attorneys, or they thought, well, this is it, she's gonna walk, or he, and it's been nope, guilty, 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 or vice versa. And I guess this one's just kind of up in the air. It's just weird. I've never saw a case done like this before.
Well, like I said, I wasn't able to watch all of it, but I have a question though about the witnesses that they had. Did they speak highly of Megan as a mother and how she treated Evelyn?
They did. They, everybody that come up there did say good things about her. I mean, they said she seemed to love her baby. She didn't mistreat her baby. She always had the baby with her. She kept the baby clean. She seemed to always have the baby on her hip. And things just kind of changed,
Once she met a boy?
Yeah, especially Hunter. But so
that's gonna be reasonable doubt right there.
Yeah.
That's gonna be one of the factors. I just hope they see through the bullshit.
Yeah, I do too. And she took her to all of her doctor's appointments up until I think the last one, right, whatever. And then when she kept lying, she lied to the doctors. And then when the doctor's like, well, you need to bring her in, or you missed this appointment, or that's not like you, she was like, well, then what was she gonna do? She's like, well, I'll change doctors, and all that kind of stuff. But she lied on everybody. Of course, we know she lied on her mom. She said, and this was a big one for me. When she was with Hunter, which they had text messages to prove that Hunter didn't know nothing about it, because she kept telling him, she's with mom, or what's his name? The guy that's supposed to be the father. He had got custody, or this, that, or the other. It was always something. So everybody knew Hunter thought it didn't happen. But Hunter took her over to his the baby's daddy, Ethan. Thank you. The baby's daddy, Ethan, at the time, who they thought was the daddy. Hunter stayed down. She told him to stay down at the car at the end of the driveway, because he thought Ethan would try to fight over her or some bullshit.
Oh my.
Yeah. She goes up the hill and stays a little bit and comes back and tells Ethan that she saw Evelyn and da-da-da-da-da. But see, no pictures, no nothing like that or anything like that. I mean, are you serious right now?
Mm.
I just can't with that one. I just couldn't. No pictures prior, before, or after. No. Mm-mm. So, yeah, that one got me. I was just like, whoa. And she had a memory box. Who else had a memory box? She had a memory box.
Mm.
But other than that, all of her things in the house, with the exception of one little dress that still had tags on it. I guess somebody might have got it a Christmas present or something, and one cup. Everything else was out there in that shed. Everything threw away like garbage, just like she was.
Wow.
Yep.
Wow.
Yep. She was always living with someone.
I knew that. Yes. And they had set her up in that trailer.
Yeah, her daddy paid for everything. Yep. Yep. I mean, she had it. She had it made. She didn't have to pay no bills.
No, she had a car, a trailer. She had government assistance as well.
She then she decided to get her job at the chicken shack. That's where she met Hunter. And I guess
Oh, the chicken shack or whatever it's called.
yeah.
Something shack.
And I guess she just thought she seen dollar signs, and they had pictures where they went out to it said apartments, but it looked like more of a duplex. It looked more like a house, but
I saw that. It looked like a house to me too.
Yeah. And on the application, it had 3 people, but it was not Evelyn. It was supposed to be for the baby that was a fake baby.
Yeah, the fake baby.
Mm-hmm. And him and her had pictures of them furniture shopping. It was just a lot.
So my biggest fear is that she's going to get off on some kind of manslaughter case. That's my biggest fear. It's going to be knocked down to something because of it's going to be something like manslaughter, some type of something. That's what I'm terrified of.
A lower charge, yeah. Well, hopefully today, when the prosecutors told them and showed them, if you check this, you don't have to go to a lesser charge. Hopefully that really resonated with them.
Yeah.
And hopefully they won't go to any lesser charges. I hope not, after what they've seen in there.
I agree.
And they don't, want to go through all those little bitty charges. Hopefully.
Well, I was impressed with the judge for putting together a notebook so they could follow along. That was interesting. I've never seen that done before.
Yeah.
I haven't personally. I haven't.
Yeah. I do like the judge. The judge was really a no-nonsense judge. I really do like him. I like that he finally moved his microphone up to his mouth. I like that we could finally hear him today. I don't think I could have tolerated him reading 80-something pages and us not being able to hear him.
Yeah, that would have been very aggravating.
Yeah. So there's that part. But yeah, I liked him. I did not like, and again, that was his job, but I did not like him threatening to put Miss Tiger in jail yesterday. The medical examiner.
Yeah.
She was a tiger. Roar.
I heard about that. I was like, what?
Yeah. Oh, stay safe, Elizabeth. She's got tornado warnings over in Alabama and Mississippi. Girl, where's Summer? You been watching that, or you just been watching me, honey? You better be prepared too.
Oh, goodness. Y'all better watch out.
Y'all better be safe over there. Lord have mercy. Yeah, Dr. Tiger is my hero too, Millie. We got her a nickname, Dr. Tiger.
That is so cute.
Yeah, she was being sassy, especially the judge told her, said, all right, they called a sidebar, said, all right, I'm going to give you one more time. And it's going to be yes or no. Do you understand? She's like, yep. So Mr. Scott asked her again, and then we thought she's going to say yes or no. She was fixing to tell it again, honey. But she was standing up for she was standing up for baby Evelyn.
That's what I'm talking about.
Yeah. But then she looked. They had the DA was so like he didn't know what the hell was going on. He got up and called. He got up and called the judge, ma'am. He said, hey, yesterday, it is not funny, but yesterday was the best at the end.
Well, let me ask you this. Do you think that if she is convicted, do you think she should get parole? Because I don't.
No, absolutely not. I hope she never sees the outside of a prison. No. Nope. Absolutely not.
Me too.
But,
Me too, girl.
We'll just have to wait and see what happens. I feel like if we're lucky enough to get her in there for life,
they might handle her behind bars.
Yeah, but this case is so strange to me. It really is. It's not as cut and dry as it should be, in my opinion. I think they're probably going to give her a chance to get parole. I don't think we're going to get it all. Honestly. I don't know. We might get surprised.
Girl, I'm going to tell you something. I remember how disappointed I was with Casey Anthony.
Yes.
I am terrified that this could play out similar.
Well, and the reason I'm worried about this so much, everybody, is because the difference in Casey and this one, Casey did walk. The difference, I'm scared something similar might happen is, I'm so worried is because she has spent 5 years in jail, and I'm scared they're going to go, well, we got reasonable doubt, time served. That's what I'm scared of. I'm just not, maybe I shouldn't be like that. Maybe I shouldn't say that, but it's just my thoughts. I don't know.
No, I mean, it's a fear of mine as well. One thing that I am looking forward to, other than the verdict, of course, I am actually looking forward to the actual jurors who agree to do interviews.
Yeah.
Those are the ones that will say, this is the reason why we came to this conclusion. This is how I felt about it. This is what I witnessed in court with her behavior. I always look forward to hearing from the actual jurors because sometimes they will agree to do interviews.
Yeah.
And I really want to hear firsthand, these people literally had front row seats to everything.
Yeah.
And I really am interested in to hear what they have to say, and whatever their conclusion may come today, tomorrow, whenever their verdicts will come in. I'm just very curious of what evidence, what did they base that on? And how do they feel? Like, were they all in agreement? I mean, that point to whatever they came to an agreement on.
Yeah. Sometimes they will. I remember back when they did Scott Peterson's and they sat down and did that. I mean, this is just as important and just as big, you know. And when they're sequestered like that, they have the opportunity to give the interviews when they're sequestered. It just depends, and I agree. I hope they do, but it just depends on you know, what they're thinking, I guess. Yes, they did Sugar Nova. They
I can't imagine. Oh, I cannot imagine that, Smiley.
I know.
I mean, I saw pictures of the baby when she was alive and smiling, and oh, she was just a little doll.
I know. Yeah, she was so cute. She was a beautiful baby.
She really was. And every time I think about how her mom treated her, I'm just like, how could you do that to an innocent child? To your flesh and blood?
Yeah.
How? What in the actual hell were you thinking? Because to my knowledge, she wasn't even on drugs. She wasn't an alcoholic. You know what I'm saying?
Yeah, that's what I don't get. That's what I don't get, because even if she was, I mean, it didn't come out anywhere that she was on drugs. And
no, so I mean, there's no excuse other than she's freaking evil.
Yeah, just pure evil.
Yeah.
You know,
she can't even blame it on drugs or alcohol. It's just who she is. It's her.
Yeah. I don't get it. I just don't. I don't understand it at all.
Oh, well, hey, where Summer says that she did do drugs.
Yeah, I mean, I know that's what they say, but they never come out and said it in the anywhere in the news or whatever. I mean, you can't. I mean, I know that you say that, where Summer, but that's what I said from the beginning. Okay, Mark, I'm here. You can't say that because there's no it hasn't come out in the news. Where is it at? I said, if somebody has it, and if you have it, please show me. I don't want to put that. It's not that I don't want to put that on her. I just don't want to put any false information out. And I'm not saying you would give me any false information at all. The only reason that I'm saying that is, and the only reason that I'm saying that is, I understand if Hunter did it. I understand if her boyfriends did it. I understand that. But listen, when I was growing up, when I was a teenager, I could be around 100 million people that did drugs. I could be the one in the crowd that did not do drugs. I'm just telling you. Now, did people, I understand, but listen to me. Did people maybe look at me and say, oh, she does drugs because she's hanging out with this bunch right here? They probably did. And they probably told my mama. Okay. But when I swear on a stack of Bible, I was not doing drugs. You can't go around judging everybody that's hanging around with people like that. I don't care. I'm just telling you, you cannot put that on people. So I don't want, look, she is a horrible person. There's no doubt about that. But I don't want to put that on her. I don't want to say that. Where is it at? Show me the facts. It's not you. It's everybody that comes in here and wants to bring misinformation. I'm not saying you bring, of all people, misinformation. That's not what I'm saying. But I'm just saying I don't want to put that out here because I, Smiley, don't know that. You see? And there's nobody yet that has brought that to me. Bring it to me. I'm begging you to bring it to me. It does not mean there's people that goes in bars every single day. There's one bar here on this beach that is a locals club that everybody goes to. Everybody knows it. It's Schooners. Everybody knows it. But that don't mean everybody in there drinks or everybody is alcoholics. I'm just saying. And I'm not mad. I'm not fussing at you. I love you to death. But I'm just saying. If she's doing drugs, I want to know. I'm trying to learn this case. I want to know. I've just never seen that. I've been asking for 7 days now. Please bring it to me. I want to know. I just don't feel like putting that on her. Has anybody seen it?
I haven't. That's why I said that.
Yeah, I've never, not once seen it in the news or anywhere. And there is no, yeah, I agree with you, Where Summer. It does not matter if she was on drugs or not. There's no reason, absolutely, to harm your child in any way, shape, or forms. Let me tell you something, and that's another thing. I've known every drug addict to man growing up, and not a piece of shit that I've ever known would harm a child the way these parents are harming their child to this day. That's where I have a problem at.
Right.
I'm just telling you. They just don't. It's pure evil. Now, drugs, do they play a part? I'm sure they do. But there's not one drug addict I've ever been around that would harm their children because of drugs and do the shit that they do to these kids that they're doing that I see here on these YouTube streets and everywhere to this day. I'm just telling y'all. Y'all think Smiley ain't been around the bush? Well, I'm sorry to tell you, I have.
Smiley's been around the bush, y'all.
I've been around the bush. But if you know it, show me. I'm asking you to show me. Show me. Anybody, show me. You can
Yeah, I haven't seen that. That's why I said it. I haven't seen where she was a druggie or anything like that. Now I know she probably did marijuana and stuff like that. You know, a lot of kids do that. They drink all the things, but I was just kind of curious, you know. She hadn't even got that as an excuse.
Yeah, I mean, there is no excuse. There is no excuse for her. She is a liar. You know what? That bitch would probably say she did drugs just to be making up a story if you want to know the truth about it, because she lies so much. She lies about the time of day. She lies about everything. I mean, she's proven it in this case. She's a liar straight up and down. She lies about everything. And why does people want to lie about the time of day? I don't get it. She's lied through this. Right, Kelly? She's lied through this whole entire trial. I don't know how people do that either. She's make-believe. Yeah, pretending and imagination. This girl could be... Annabella, I swear to God, this girl, you probably wasn't in here. I said she could need to go to Hollywood and be in the movie. She could cry on a dime, and she could she'd be a great actor.
Honey, the way she's got this active imagination,
Yeah, she'd be a great actor. For the love of Jesus, like, what in the world? I don't know. I don't know what's wrong with these people.
I don't either, girl, but it's getting one thing that the world is an evil place. There's a lot of bad people in this world. But one thing I cannot fathom is someone hurting their own child, someone hurting an elderly person, someone abusing an animal. I mean, I just don't, something is they're flawed. They're damaged. They're tainted. They, you know?
Yeah. And I agree, Lynn, Why can't they find Summer? You know, Summer deserves to be found too, you know, and you know, I just don't understand. I don't understand. And here's another fact. Here, Don Wells said, remember that, Annabella? He said what? He went and searched for Evelyn.
He did. He said he went and searched for baby Evelyn. He sure did.
Now, what y'all think about that?
That's some shit.
I don't know if he did or not. I mean, I don't know. I just don't know. How he said he went and searched for Evelyn, and then he said he what did he say? He gave money to the one that had Elizabeth Smart.
The one that was found down the road, you remember her?
Yeah, remember that?
Mm-hmm.
I just don't even know. This is just wild. But we can't find Summer. We can't find Summer. That's what he said, Kelly, the OG.
Yeah, he did.
He sure did. He sure did.
I mean, just think about the Sebastian case.
Yeah. Yep. And you know, these babies, they need to all be found. All of them. Every single one of them need to have their day in court. Oh, and Carly Trent. Yep. What about Carly Trent? Yep. Oh my, me, oh my, oh. No, I don't think it's too late, Lynn. I think one day Summer will have her justice. But it may be years. It may be years. Unfortunately, right now, I do think that is a cold case. Unfortunately.
Yeah. There's nothing new. The law enforcement hadn't even given us an update that there is no update. You know what I'm saying?
Yeah.
I mean, it's almost like she's not even a priority.
Yeah. Yeah. Very sad.
Mm-hmm.
Very
It
sad.
is.
Yep. Yep. Yep.
So we're on a jury watch. I'm excited.
I am too, and I'm hoping and praying
Mm-hmm.
will come in today. That's all I hope.
I do too, girl. I don't care if it's at midnight. I'm here for it.
Me too. Me too.
But I'm going to put you on my radio because me and you about to go to Walmart. So I'm going to drop back down and chat.
Yeah. I don't even know what to do, girl, because Lord, I don't know what to do. How long
We're on jury watch. I don't know how long they're gonna take.
Let's see. 3, 2, 3. They've only been gone like 30 minutes or so now. So I don't know. I think it's gonna be a while. A little bit anyway.
Kelly, the OG, she says that she thinks that CP and KP studied Summer's case. Honey, they actually said they followed that case. You remember that? You remember that, Smiley?
Oh, I don't remember saying they followed it.
Yes, Chris said he followed that case closely.
Lord, I might have. I don't even know right now.
You don't remember Chris saying that he knew about the Summer Wells case and he followed it closely? Because it was in Tennessee?
Maybe.
East Tennessee?
Oh, God. I might have. My brain's just not working right now. Don't hold me to that.
Oh, Shannon, yeah, you're right. Oh, see? Rach remembers. Yeah, I remember CP say that. Mm-hmm. I promise you, I ain't making it up.
Oh. That might be where he said, it might be where he said he, how did he say he, it's not investigate. What's that word he said in my live or where he checks out people? He said in my interview, he said, I actually something. And he said, I've actually did that to you too, but and I kind of laughed. What was that word he used? I can't remember. And
And what does it mean? What does the word mean?
it's kind of where they kind of investigate you, not really, I can't think of that word he used, but anyway, when he come on my live, it's kind of like where they check you out or something, and
Vetted you, maybe?
yeah,
Vetted
vetted.
you?
It's like, yeah, vetted. Yeah, thank you, vetted. And he's like, I vetted you, and I kind of laughed because I was thinking in my head, that's
What
what
a psycho.
I said, oh my God, because I kind of laughed. I was thinking, oh, have you seen any of my Summer Wells videos? I was thinking, oh my God, that's what I was really thinking. Like, because I was really green and wild back then for real. And I thought, my God, well, maybe hell, that's why he got to me. I don't know.
I'm goofy.
He got a surprise, I think.
Yeah, he did.
That's called growing. Yeah, Holly, they are deliberating.
Yeah, I'm excited to see what happens. I'm not going to be able to rest because I'm going to be checking constantly. But I'm going to fall back down in chat. I'm going to put you on my radio. We got to go to Walmart, so we got to pick up some stuff for the mama.
Okay.
Today was her first day back to work. So I'm going to go and take care of all her running around business this afternoon because I found a list that she made for herself. So I'm going to go take care of it so she won't have to.
Oh, good. Well, y'all drop Annabella's link in there and go sub up to Annabella because she has a beautiful channel over there, and she don't do much of true crime. She follows it, but she has some words of wisdom for us all. So go over there and sign up to her, and we love her over here.
Thank you so much, Smiley. You're going to make me cry. I love you, girl.
I love you too. Thank you for coming up.
Absolutely. Absolutely. Bye.
All right, bye. Yep, we on Verdict Watch now. Verdict Watch. Thank you, Reality Wins. I like that actually. We on Verdict Watch. Yeah, I don't know. We on Verdict Watch. Well, hopefully, I don't know if it will go all night or half a night or up until tomorrow. I don't know what the guess is. I'm trying to go back here, and I keep trying to go back and see what's his name, Mr. Scott, gave me any interviews yet. Let's see. That's what I want to know. I want to know how he's feeling about this. Let's see. No updates yet that I see. Unless somebody else sees one, I don't see one. Let's see. But okay, so they took the one charge off. So she is facing 19 charges, is what it's saying right here. So they took that one off. Remember when they first got started, Fun to Ski? Because I remember you saying 20 earlier. I thought they took that one off. At least that's what Court TV is saying. Let's see. WJHL hasn't come back on yet. I bet you anything, though, Ansley will get one later. Hey, I see you. No, the Wells thank you, I see you for that. The Wells and Bauer socks are not related. They absolutely are not related. Yeah, they have come back before at nighttime with verdicts. Yep, absolutely. Absolutely. You've been chasing your 8-month-old grandson. Yeah, absolutely. You feel like the verdict will be tomorrow before lunch? Let me see something. Yeah, they're not related, but CP did mention they're saying Summers' case months ago, and you don't remember where it was at. Okay. Yeah, but there was, I guess they're saying he said that they followed that case because it was in Tennessee. So mad at myself. She got a chance to go shopping with my daughter and stay long shopping because hurting so bad. Oh, I'm sorry. Yeah, nothing like being a grandma. He also mentioned the Watts case. Wow. I'm sure that they have watched a lot of these cases on here. I knew they were on here before. Thank you, Reality Win, for subbing to Annabella. Thank you. Let me see something. Okay. I was just going down my Facebook, and on Trevor's it says, just for reference, premeditation in Tennessee only requires the intent to kill be formed prior to the murder. It can be 2 seconds prior to the murder. As long as she had intent to kill before killing, it's premeditated in Tennessee. There's no time frame for intent to be formed. So that's just FYI. Okay, thank you always. Yeah, that's good to know. That is interesting. Let's see what let's see something. I think that's pretty much everywhere because I have always heard that. All right, let's see what this says. Hold on a minute. No, that's something else. Hold on. Hold on. So, but I'm not sure that they would be able to prove she was I don't know with what went on yesterday if they'd be able to prove she was, if they're going to have reasonable doubt, I guess is what I'm saying, before she was put in the trash can or not. I don't know. they supposed to have more witnesses than they had? I'm just curious as to why they didn't call them all. Hmm. Pulling up something here. Wow. Okay. I was pulling up. This is the lady. This is Christy Broom. This is the lady that was talking with Megan in that one interview. Her daughter had passed away, and remember that interview? That's who she was, and was saying how her mom, talking about Megan's mom was trash, yada yada yada. This is the one where the interview was at the cemetery or whatever. And I was just looking her up, and I don't. The only thing I was looking up is I want to see if she had any photos of Megan, which I'm not on her friends or anything like that. So of course it don't show everything. But it was interesting to me. She has a red Grand Prix. Didn't wonder if she bought that from Megan. Didn't they say Megan had a red Grand Prix? Anyway, never mind all that. That's not important. Well, it might be, but never mind all that. Who cares? I don't see any pictures. I might be missing of Megan. But what was interesting to me is, I'm not going to put them on here or anything, that she had, I don't know if they were her daughter's kids or whatever, but she has a lot of kids. I just wouldn't want my children or grandchildren around Megan. I'm just saying. And I just wondered if some fluke happened that Megan did get out. Would these people allow Megan to come live with them? I'm just wondering. There's notes on here or text messages on here to her from Maggie Wood. And I'm letting y'all know that in case you do want to read those. Christy, Maggie Wood, are you on your way back to the police station now in safe hands? I will just say from the 2 days I have spent with you that you have done nothing but lie to me. So I don't guess they're friends no more. Okay. And I am the one person that had your back, and I don't understand why you absolutely know more. I don't understand why you absolutely know more about where Evelyn is. If you want any kind of future at all, like I told you, then you need to tell what's really going on and not change your story unless it involves the truth. By the way, You're not pregnant. Oh, she called her out. Okay. You're not being the doctor. You're not being to the doctor. There were no prenatal prescription vitamins for them to confiscate TBI. I mean, your story isn't adding up. And for 2 days, I've been not being able to comment on here. I've been had your back. I still have your back. I've known you since you were in kindergarten. You were best friends with my daughter, Maddie Broom. You've lied to the point investigators don't even want to talk to you anymore. That needs to scream something to you. Your future is on the line. If you are innocent, I don't think you hurt Evelyn. I just think you know what happened afterwards. And you need to tell them where she's at. I know you know. That was interesting. That was back in 2020. Yeah, that was her. That's the only thing that I see on there from her. But I just thought that was interesting. In a way, the way she makes it sound, I don't know. Sometimes I wonder if these people were trying to cover people's asses, though. That's what I wonder. You understand what I'm saying? If they post that, because you see how she was talking in the interview, and then that was back in 2020. I don't know. Just my opinion. Just my opinion. I don't know. I'm going to turn on some music and I'm going to let y'all talk amongst yourselves a little bit more. Because I want to keep it up to where y'all can talk a little bit. I want to keep it up a little bit and see if they come back. I got it on my phone. Well, let's see. Let me see. Hold on a minute. Hold on. I got it on my phone. I'll just turn on some music on here, and I'll keep watch out on Court TV. Hold on, and y'all can talk amongst yourselves. Hold on. Where's media? Media. And I'll be back in just a minute. Where is something good? Hold on. Trevor don't have a channel. It was on his Facebook. I just come across it on his Facebook. He's not on YouTube anymore. All right, it's been It's been 1 hour and 50 minutes. 1 hour and 50 minutes. So, Casey Anthony was 11 hours. Not guilty in Casey Anthony's, of course. Let's see. My hubby works in law enforcement, and sadly, he sees many of these types of cases. What does he think? Or did I must have missed your comment. What did he think? What does he think? Let's see here. Let's see. OJ's jury deliberated less than 4 hours. And his, of course, was not guilty. Let's see, Scott Peterson's. Ooh, that scared me. I thought that they was done. They had a juror removed and everything in that one. I forgot about that. So they took like 9 days in Scott Peterson. They had, I think they had 2 jurors removed. One was for misconduct, definitely. They had, let's see, 180 witnesses. His was a pretty wild trial too, but his was wild, you know. Rhonda says he thinks they're going to find her guilty. Yeah, oh, I bet. And that's another thing. It's hard to, any profession that somebody's in, they be talking about their job. I don't care what nobody says. And when you're in a job like that, it's very hard to listen to things like that. I can only imagine. We don't know, Bella. We're just wildly guessing. We don't know. We're just hoping. Kendra, that's usually up to the judge. That would just depend on the judge, really. There's not really a set time. It's already 5:15 there, but they have went. We've seen them go before, you know, and different things, 7, 8 o'clock, 9. It just really depends. Hey, H. Davis. Glad everybody's coming back. The Drew Peterson jury, remember that cop? They deliberated 9.5 hours, and they found him guilty of murdering his wife. 9.5 hours. Yeah, I think he should have called them by numbers. That's what I think they have numbers for. I don't know why he knew it was televised. And I'm not sure why they did that, because isn't that the whole point of them being sequestered and everything? He's the one that made the mistake there, and I don't know if that could be a grounds for anything or not, even going forward. An appeal or anything else. I really don't know. I think, you know, that's why they have numbers. I just don't think that was should have been done, to be honest with you. I don't know what he was thinking, and I don't know if I don't know. I don't know if anybody caught that. I don't know. Obviously, you caught that. Angel, I think it could be a cause for some problems down the line, honestly. But that's just my opinion. I mean, who am I? But yeah, he should have never done that. That's just my opinion. The jury has a chance to speak after if they want to, but they never have to reveal who they are if they don't want to. No updates yet. It's been 2 hours and 10 minutes. Have not heard anything about the remains yet. Thank you for doing the thumbs up. Hi, Woman's Warrior. It is actually 4:22 here and 5:22 where they're at. And we're hoping, some people think it'll be tomorrow. Some people are hoping it will be tonight. We just don't know. We've been waiting 2 hours and 15 minutes. Verdict watch right now. You think 4 hours and 30 minutes to 5 hours? Yeah, that's pretty. I mean, that would be pretty reasonable, I think. Let's see. OJ's was a little bit, I think, less than 4 hours, but he was found not guilty. We were just talking about that. I think pretty reasonable would be about 4 hours, something to that nature. Yeah, technically where they're at, it's 5:23 now, Shannon. And don't forget, they're probably eating dinner, and they have the opportunity to probably eat dinner during, instead of taking a break, they probably are bringing their dinner with them. I know when we were on jury, we had the opportunity to do that. So they probably have the opportunity to bring their dinner and work at the same time. It's just totally probably up to the jury. Let me look. I don't know how long Leilani's was. Let's double check that. Checked everybody but hers. Yeah, they have 2 time zones. They actually have 2 time zones. I don't see about the Leilani how long it took. To deliberate. Why am I missing that? See everything but that. Says they read through the judge's instructions several times. Not so much on the witness. I'm missing it somewhere. I know they had problems. They had, and that's all I'm pulling up, so I don't know. I didn't really follow that case. Let's see. It lasted 10 days. I don't know exactly how long that one took. Hey, Kimbo. Oh, 6 hours. Sonia's saying it took 6 hours, 6.5 hours. Thank you. Yeah, I didn't really follow that one. Oh, here we go. Oh, okay. Here we go. Yeah, she was guilty. She was guilty on 19 counts. Okay, so yeah, so it took 6 hours for her. That was pretty quick for all them charges too. So really, thank you for that. All right, let's see what else I'm getting here. All right, let's see. I missed something here. Hold on a minute. Um, yeah, he was. All these babies were. Um, let's see. I don't understand, and I remember. Let's see. I had heard. Hold on a minute. I had heard, Smiley hadn't heard of it until the trial. I tell you, Smiley, amazing police work and community coming together. Absolutely. Well, I think Sullivan County and TBI did a excellent job on Evelyn. I really do. I think it was just the state, to me, who didn't do a great job. But now at the end, they brought it home. Now it remains to be seen if the jury thinks that they proved it beyond a reasonable doubt. You know, that's what I'm kind of worried about. That's the only thing, I'm worried about. But we'll see. I mean, just got to have a little bit of faith. A little bit of faith. I mean, look at Evelyn. Just got to have a little bit of faith. I know. Why? That's $1 million question. Yep. But for all these mothers out here who can just know where their children are, and like this one, and Kate, like they're in a trash can and they're here and they're there and they're God knows where. And the mothers know these things. It's so appalling to me. Woman's warrior, I hope so. I pray so. I pray so. And I hope it comes in tonight because I got so much work backed up that I have to do on these other cases and stuff. And tomorrow's the 12th. I think that's the one you sent me weeks ago. I think I have it ready to go. I hope I didn't get it mixed up with my other papers because God knows I worked on it for a long time. Lord have mercy. Speaking of that, my office is a flipping disaster in here. There's so much going on. Elijah, yep. Oh my God, wasn't he precious? Harmony, my God, I could look. I didn't even realize till I tried to sit through some of that. I wasn't covering it. But I was like, do what? They did what? Yep, that one. Woman's warrior. It did. Absolutely, it did. I was like, oh God, people need to hear this. Yeah. Yeah, absolutely. Rach, Chris come got me off of Justin Clutched in Pearls live. I was on a live panel with Clutched in Pearls, Trevor Lee, and Josh over at the lab. And he messaged me and kind of demanded that I go live right now. And I was in shock, and I was kind of like, what? It's Chris, and he wants me to go live right now on my panel. And then I kind of stuck my foot in my mouth, and I was kind of like, well, and then I kind of invited him on Justin's live, and I'm like, well, you can come up here on my live, and on Justin's live. And he's like, no, he wanted me to go live on my live, and I'm like, okay. And I just kind of got down and fired up my live, messaged him back. It was all from Messenger, and told him, look, I got to go to the bathroom real quick. I had a long, busy day, and yeah, it just kind of come about like that. I had no questions. I had nothing. I had to do it from the top of my head. And now I have many questions. I am prepared, and I told the sucker if he wants to come over, he is more than welcome to come back. I will drop him a link. So Chris Proudfoot, if you are watching, you are more than welcome to come anytime. You can come up here right now, Chris, if you want to, and let's shoot the shit while we're waiting on this verdict watch, if you really want to, honey. Because I have some questions. You're welcome, Rach. And that's a fact. You can go back and watch Justin's live, and then you can see what happened, and then you can come back and watch mine. And yeah, that just kind of happened. Thank you. Thank you. Although I'm not sure I would do as good being prepared if he did ever come back over here again, because I seem to work better on my interviews when when I'm not when I'm not when I just do it spontaneous. I had one with Don Wells like that, and I didn't even believe it was him. So I kind of work better, I guess, not being prepared. I don't know, something just comes over me. But yeah, that happened. Thank you. Fun to ski it on the fly, Smiley. On the fly and on the sly. Exactly, Sonia. Brandy's been up here before too. She just come up here on her own, and it wasn't. I'm not sure I would say that was an interview, but she's been up here. Annabella, the one that was up here earlier, me and her was up here, and she come up here. I guess it's been well over a year ago, and I really like Brandy. Brandy is a good mother and a good person. Now, I don't have anything bad to say about Brandy. She is a beautiful person. Love her. Love her, love her, love her. I have my own personal reasons, why I don't cover that case. Oh, today's the 12th, Beth Ann. Thank you. I told you I'm confused. And she understands. But anyway, she's a beautiful person. She's been through a lot. She's very, very sick right now. She needs a new liver, so y'all pray for Brandy. She's very ill, but yet she's still trying to help others. She's, she's going to get justice for Michael, for Monkey Michael Vaughn. And she's tried to help so many other children, including Summer Wells. Just love Brandy. Love her. Love her. She has so much grace about her. There's nothing you could ever tell me about Brandy that I'd want to hear that you could make me change my mind about her, ever. Love her. No, it's not. She needs prayers. She needs all the prayers she can get. Oh, thank you, Woman's Warrior. Yeah, I try to, and it doesn't matter. I'm on the victim side. I want to hear both sides of the story. It doesn't matter who did wrong, and it doesn't matter who did right. I can sit at both sides of the table. A lot of people don't understand that. But I want to hear both sides. I don't play the fence. I'm not fake. Okay? But I'm very respectful and can be very respectful to both sides. Now, until you try me, I don't take no shit. And I don't sugarcoat anything. But I will listen. And I have my questions and my own way about doing things. That's just me, and I'm not going to change. I'm not going to change for anybody. And I'm not going to be bossed around or told what to do by anybody. And throwing money at me to ask a question or this, that, and the other is not going to make me do anything any different than I would do. I'm just saying. I'm just me. That's who I am. Yeah, I just have to do things the way I have to do them. Thank you. But the way that I do it, I really mean it from my heart. I really mean what I'm doing. You can take that under a court of law. You can take it on a Bible. You can take it on your child, my dog. You can take it on anything that you want when I'm doing something. I'm doing it from my heart and exactly how I do it, from my feelings and exactly right then and there. I'm not doing anything to anybody nefarious at the time, period. Yep. Yeah, Brandy's missing Michael so much, and on to ski, and oh, I know he was her everything, and it killed me when I seen that video that she made, and she said the one thing they always did in her house was the pinky promise, and she was just so scared she wouldn't make it to keep her pinky promise. That broke my heart. Oh, I don't need nothing for my interview being played. The only thing I don't want with my interview being played, and I don't even care if the other side plays it. I don't care who plays it. I don't care if the hateful people play it or whatever. The only thing I don't want, if it helps in any kind of way or whatever, the only thing I don't want with that interview being played is somebody to try to work their way up the ladder to build their channel and then go around bashing my friends. Oh Lord, don't even get me started on this, honey. To make them $1 off of something that I did that I don't even want no money off of. That's what I don't want. They know who they are. I have never struck anybody over a thing, but I will. Look, Smiley has lived and learned, and Smiley will strike the hell out of somebody. I am learning these people real good. My haters don't even do that. I don't want that video used for nefarious reasons. That's what I don't want. I don't care if the haters use it. I don't care anything about that. I want it to be used to help Sebastian and anybody, any learning, anything that could be done different, anything said to be helpful. I don't want it to be harmful. I don't want it to be harmful in any way. I want anybody to use it, because every time that it's listened to, even by me, I hear something different in it. I do. Rach, just rage. You do what your heart tells you to do. Um, all I'm going to say to anybody that wants to do that is just know, have thick skin. That's all I got to tell you. Is just have you some thick skin. If you're not in it for the money, you're in the right place. I don't know what people think. Only grifters make money. Trust and believe. Only grifters make money. There's no money to be made in YouTube. I ain't seen none. Hold on. I want to show you something. People say, you don't have to show your business. I know I don't have to show a damn thing. Sure don't. I sure don't have to show a damn thing. Sure don't have to show a damn thing. Sure don't. Where are we at? Look here. How many hours is this? Evelyn Boswell. Let's see. I'm just trying to get. Y'all know me and my buttons. Evelyn Boswell. Wait a minute. What is today? Fuck. How do you get? How many hours was this? I don't know how many hours it is. How many? Y'all know we've been doing this like 8 hours, right? Okay. I just want to show y'all something. Let me get my thing on. So, day five, Evelyn Boswell. Are y'all seeing that? Evelyn Boswell. Estimated revenue, $2. Are y'all seeing that? Where'd it go? Where'd it go? Hell, ain't even on there. Evelyn Boswell, where did you go? Shit, content. Evelyn Boswell. Okay. Evelyn Boswell. $2. I can't see. $2.09. Let me see it. $2.09. $2.09. I don't sit here all day because I give a damn about the freaking money. I don't care about the freaking money. I don't sit here because I care about the money. Let me see. Can't even keep my damn bone straight. Where is my stuff? I can't do it on both, but whatever. All right, is today day 6 or 7 on Evelyn? Let's just do day 6. Day 6. Can't get it up. I think that's it. Did you miss a troll? Day 7. No, they haven't come back yet. Jury hasn't come back. Hey, Seashell. No, they haven't sent the jury home. They're deliberating. They're still deliberating. I can't even buy lunch. Yeah, but what I'm trying to say is I'm not worried about all that stuff. I don't worry about that. Some people do. Hey, Seashell, I don't worry about that. I don't care about all that. That's not what's important to me. Yeah, I think they'll come back and, tell us what's going on before they close. It just depends on the judge, really. That's what it really depends on. Exactly. That's what it's about. But anyway, I didn't mean to get off on that. Just know you got to have thick skin. That's all. These naysayers, just let it roll off. Sometimes you can't. You got to choose and pick your battles. It's hard. Man stealing gets caught with a pile more bags of gold than coins. Push off that will happen. Agreed. Okay, can't remember what movie it is. Yeah. You'll figure it out. You just you got to do you. You know what I'm saying? Can't do it for your husband. You can't do it for anybody else. You got to do it for what you feel is right, what you want to do. You got to figure out what your niche is. It may not be true crime. You just got to feel your way around. It may be a mix of things. I don't know. But word of advice, don't if you get a channel, don't use any identifying marks. I would use my face down and be prepared, because if they dig into you or at any given time, whether it be the first week, 10 years, 2 days, and they dox you or your family, and they will. Everybody has a turn. Don't assume because you're married to a police it's going to protect you. It will be done to you. And be prepared. Again, you have to have thick skin. Just saying. Yeah, you need to do a psychiatric channel. There you go. We need some more of those. But you live and you learn and you grow and you realize what's important, what's not important, what matters. Look, after my mom died, nothing really matters to me. You know, it really don't. It don't. Rachel's like I live alone. Oh, I thought you said your husband was a cop. Look, I don't know. Now I'm seeing things, y'all. I don't know. I'm seeing things. God bless America. Woo! Smiley's ready for some nicotine, y'all. We all a little cray cray. I don't know what I just saw or where I got her husband was a cop, but honey, I am ready for some nicotine. I might need some meds. Hey, Misinformation, how are you doing, honey? Smiley be seeing some things down here. Oh, Lord have mercy. Well, you could deem yourself nuts. Oh my gosh. Oh, your brother-in-law was. Uh, Lord have mercy. I read that wrong then, honey. Oh my God. Well, we know somebody else's brother that was too. It didn't keep them out of trouble. So don't count on that, is all I'm saying. Oh my word, honey. Lord have mercy. Don't even start with your sister. I didn't say nothing about your sister. Oh my God. Oh, I ain't heard nothing about nobody's sister. Uh, and if you start talking about grandmas, I'm running. I'm going to be. Yeah, hey, Jude, I hope you're feeling better today. Seriously. Millie, stop. Don't make me laugh. I don't know, Misinformation. Thank you for coming over, though. And I hope things are good over at X, honey. I haven't been over there. I think I did pop over there today and drop my link, but hope things are cool over there, calm and collected. We don't know. I'm a little bit concerned, but hopefully it'll be okay. We got to have faith. I think the state picked up and really did better today. Honestly, I think they did a little bit better today with their closing arguments. The defense attorney, honey, he was screaming at the jury today. He was screaming. I don't know why the judge didn't stop him. He acted like a maniac in closing argument.
All right.
Uh-oh.
The jury has notified me through the court officers that they're ready to stop for the night. I'm going to bring them in, give the admonitions, and send them to the hotel.
I almost had a heart attack.
And it is 6 o'clock. 6:02.
Everyone stand, please.
I thought he was going to say they had a verdict.
may be seated. Thank you.
All right, ladies and gentlemen. I'm going to go through these admonitions again. You're not to communicate with other jurors or anyone else regarding any subject connected with this trial. You're not to form or express any opinion about the case till it's finally submitted to you. You're to report promptly to the court any incident involving an attempt by any person to improperly influence any member of the jury or a juror's violation of the court's admonitions. You're not to read, watch, or listen to any news reports concerning the case. You're to decide this case solely on the evidence introduced in the trial. Now, when you get back to the hotel, you're not to deliberate. You only deliberate in that room.
Oh my God.
That's 11.
They ran.
I don't think we have Ms. Rucroft.
Uh-oh. Ruh-roh.
They all left you. Okay. We'll go through this one more time now that we're all back together. You're not to communicate with other jurors or anyone else regarding any subject connected with the trial. You're not to form or express an opinion about the case until you finally decide it. You're to report promptly to the court any incident involving an attempt by any person to improperly influence any jury member or a juror's violation of the court's admonitions. You're not to read, watch, or listen to any news reports concerning the case. You're to decide this case solely on the evidence introduced in the trial. All right. Yeah, you can go with the officer. Have a good evening.
Why is he saying their names is what I want to know. Well, that's it for the day. Lordy, honey. No verdict tonight. No verdict tonight. Probably not used to it being televised. Yeah, but still, well, he's probably not used to it being sequestered. So there's that, right? Okay. Well, in the morning, 8 o'clock, we will be here. Be on time. Let's set the ground rules. Be on time. No. Oh my word. Oh my word. Be on time, and we will watch and see what happens tomorrow. That's all we can do. That's all we can do. Hey, Jack of all trades. Yeah, those that didn't see the closing arguments, go back and watch them because he was yelling. He's very confident. So we'll see. We'll see. I don't know. I appreciate each and every one of you being here with me today, coming in, dropping in, saying hello, coming in. Some just come in and gave me a thumbs up. They said they were working and all the things. And I truly, really do appreciate that. You don't know how much your support means to me to come over here and, just drop in, say hello. 9 long hours, a little bit over 9 hours, 9 hours and 18 minutes. Thank you for everything that y'all do, for these kids as well. And, I will see y'all somewhere on the streets tonight, I'm sure. So get you something to eat, rest, and we'll go at it again in the morning. Thank you, Annabella, for coming up here too. And thank you, mods. Thank you, everybody. Thank you. Have a wonderful night. Love y'all. Bye.